Permitted to mention one restoration application.
Please give.
My lord, may I
Any-
permit to mention one intercourt appeal arising out of respondent authority issued a punitive order for transfer without following the office guideline for transfer. It's an intercourt appeal.
List it next week.
One.
I'd like to appear for the petition of my lord. Grateful, my lord. After obtaining the certified copy, my lord, I have communicated the order to the state for the writ petition and affidavits filed earlier. My lord. My lord, there was an order of 17th May 2024, whereby affidavit was asked for. Specifically, my lord, my lord takes up the order dated, my lord, 17th May 2024. Two memorandums were, my lord, directed to be filed along with the, my lord, opposition. They have used opposition, filed opposition, but these two memorandums had not been, my lord, produced because, my lord,
What is the matter?
yes, my lord, my father was a Group D employee, my lord, in the state service, my lord. Since he was very much ill, my lord, he applied before the authority that, along with his medical documents, seeking, my lord, to appear before the medical board to, my lord, adjudge his, my lord, incapacity and medical illness, and so that, and thereafter, my lord, voluntary retirement on medical ground. What the authority has did, my lord, they never, my lord, consulted any medical board examining my lord, health condition. Rather, on the basis of the documents as supplied, they have given me retirement. My lord, as per the my lord scheme, compassionate appointment, if a person, my lord, uh, retired on medical ground before attaining 2 years of superannuation, his, my lord, son or dependent can apply for the, my lord, compassionate appointment.
That is a provision.
That is the provision.
Maybe not. After exhausting all leave to the credit of the employee, if he still has 2 years left, then only his part will be considered.
My lord, as per the West Bengal laws, rule prevailing in West Bengal, yes, ma'am.
So this disabilities, the medical board was not constituted. That is the grievance.
And my lord, I do not know, my lord. Medical board was not constituted. I did not ask. They allowed.
Didn't want a medical examination.
Already, my father died. It was happened in 2020, 2015.
What was your prayer before the? What did you want from the authorities? That we are asking.
Compassionate appointment.
On the ground of his demise.
No, my lord. Incapacitated, medical reasons.
How
he was retired on medical reasons.
So when you applied for medical examination, that is what we are asking you.
Yes, that is the date, my lord, before 2 years, 2 years before he is attaining, my lord, superannuation, before 58. That is the provision, my lord.
Where is the application?
Yes, page 30.
By your father.
Page 30.
Please.
30. Page 29 is the forwarding letter by the department, and page 30 is the representation. T0 page.
What was his date of retirement? Superannuation age?
Superannuation would be, my lord, he would attain 50 years, 58 years. Retirement on, my lord, date of retirement 31st August 2015. Normal date of retirement.
So how he does not have 2 years?
Yes, my lord, age 58 would come on 31st August 2013.
On 15. 31st August 2015.
15 is the date of retirement, scheduled date of retirement.
Achha.
He would come 58 years at 31st August 2013. He applied on 22nd May 2013 before reaching, my lord, 58 years.
How many days of leave he had in his credit?
No, my lord, nothing, no leave.
Where is this fact?
My lord, that fact is already in the file, my lord, in the
Already in the file.
in the office file of the authority, my lord, in the tribunal, my lord. And have a look to this particular document. A report was called for by the tribunal. 117.
You are relying upon the provision contained in the scheme, clause 6.
Clause 6.
Now, clause 6 says that he must have 2 years left after exhausting all leave available to his credit and under any head. In your case, you have 3 months more than 2 years, if this is the date of your application. So you will have to show us that there was at least 4 months, 3 months, lesser than 3 months leave to your credit. Then only you can be considered. Otherwise, you cannot be.
All leaves have
Because under the scheme prior to 2016 Act, there was a provision for constituting a medical board. Under the 2016 Act also there is a provision for constituting a medical board. That says to be done within 4 weeks or within a month. So that 1 month they have anyway. How your claim will be admissible? That is why we are asking you.
My lord, as per the report, my lord, kindly have a look to the report. My lord, page 117.
Yes, what is it you want to show from the report?
My lord, while deciding, the tribunal by an order dated 17th March 2022 directed, my lord, the department to produce the documents regarding the medical board. That order is at page 116, and page 17 is 117 is the, my lord, the report. My lord, kindly have a look to the.
Yes, read what is the important thing.
Yes, my lord. They say, my lord, they have not constituted medical board. However, my lord, it is only mentioned that there are satisfactory documents justifying incumbents' plea for VR on medical ground. So, without, my lord, constituting medical board only on the basis of the document, the authorities satisfied themselves. Yes, this person is eligible for medical ground retirement. So, my lord, this is the context, my lord, and my lord, so far the leave is concerned, my lord, I am the son, my lord. This has, my lord, certainly this, my lord, leave has not been there. Otherwise, my lord, the medical ground, I could not have been, my lord, allowed to retire.
Oh, all on presumption.
My lord, I do not have the documents, my lord.
You don't have, that's why we are asking you, where is your father's application saying that, look, give me a leave, I wanted to be declared incapacitated. He has not asked for your appointment. He only wants a voluntary retirement. He doesn't want a compassionate appointment.
My lord,
When did you first make the application for a compassionate appointment?
Soon after.
What is your first application?
Yes, my lord. That is.
Show us.
Yes, my lord. Page 44.
Date, give us the date, please.
30th July 2024, 2014. Soon after declaring retirement.
Page?
Page 44.
So he was voluntarily retired.
The authority, my lord, page 42 is the document by which I have been retired. But that document does not say, my lord, on what ground I have been allowed to retire. That is why, my lord, by the previous order, court directed.
Just a minute. This
Page-
44 is by you, not by your father.
No, my lord.
And your father, he's alive.
No. Not,
What is the date of his demise?
my lord, he died subsequently, my lord.
After attaining the age of 58.
Yes, my lord. In the retirement order, my lord, nothing has been, my lord, spelled out regarding in what ground, my lord, he has been directed to retire.
On the ground which he wanted. He wants a voluntary retirement. He says, I'm well.
My lord,
That is what has been said.
my lord, kindly appreciate this presentation, what he prayed for.
Nothing. See, please try to understand there are under the EMP that you are claiming the benefit.
Yes.
You will read clause 6, then
Yes,
you will
ma'am.
realize what I am saying. Everyone who retires or voluntarily retires, their ward will not get a compassionate appointment. Perhaps your father was well aware of this.
My lord,
So he did not ask for anything like that. He said, I'm unwell, please allow me to retire
my lord,
voluntarily.
kindly have a look to the prayer in my my father's
Say anything.
my father's
We
representation.
have seen that. He does not say anything about the appointment. He does not say incapacitation.
Yes, my lord. My lord,
He does not use the word incapacitation. We have gone through it. If you can find something, tell us.
my lord, page 31, that
Please read what it says. I'm incapacitated.
I humbly submit before you kindly to arrange my appearance before the medical board for unveiling the truth about my physical incapable condition for discharging of my service.
Yes, but he asks for the certificate. That's what we are saying.
And thereafter, my lord, he
Now come to MP. Read clause
my lord,
what it says.
yes, my lord, I'm referring thereafter, my lord, it says, it is therefore prayed that your kind self will be pleased to consider my application for making me appearing before the medical board for the purpose of granting my voluntary from the service of life.
Voluntary retirement is different from the retirement
Medical ground, on medical.
Read 6. Read clause 6.
Yes.
That's a totally different concept from voluntary retirement.
Completely different.
Completely
In case,
different
my lord,
concept.
if he voluntarily retires, he cannot claim. But in the case of
Please read.
first, my lord, application is under clause 2. The application says it shall apply to a dependent family member of a government employee who is disabled permanently or otherwise incapacitated, rendering him unfit to continue in service permanently on being declared permanently incapacitated by a medical board formed by the government.
Correct.
My lord, that is at page 14 of
Yes.
my reply.
Yes.
Affidavit in reply, that circular is there. Page 14.
Page?
14 of my affidavit in reply, my lord.
Which circular?
That is 251, my lord.
We have it, don't worry. We have it. EMP 251, we have.
Clause 2, my lord. Clause 2B.
Yes.
Application. This shall apply to dependent family member of a government employee who is disabled permanently, otherwise incapacitated, rendering him unfit to continue in service prematurely on being declared permanently incapacitated.
He never sought that declaration that again and again we are telling you. This is not the first case that we are seeing. Whenever they seek an incapacitation, they write to the authorities that it declare me incapacitated and take my sons or my wards or my dependents consideration for a compassionate appointment. He did not want it.
My lord,
He said, I'm unwell, just check up and let me retire. He was not incapacitated.
my lord, subject
If
to
that was the circumstance, he would have asked for it because there has to be assessment in terms of the Rights of Persons with Disabilities Act.
my lord,
Because clause 6 of 251 EMP is in light of the provisions contained under the Right of Persons with Disabilities Act. Unless you are disabled from working, your ward will not get a compassionate. If you say, I don't want to work, then yes, you may be voluntarily retired, But your ward will not get an appointment.
My lord, subject to
And
correction.
there is no declaration, so there is no question of your
My lord,
compassionate
subject to
appointment.
correction.
Impossible.
My lord, subject to correction, my lord. Until a person, my lord, is declared medically unfit,
Correct.
my lord, his right of this, my lord, circular, right of getting appointment, my lord,
Yes.
would not, my lord,
Cannot be. That's precisely what you are saying.
would
That
not
is
come.
the-
So, my lord, the father asks before the authority to appear before him the medical board by the representation.
Yes.
By this representation, he asked.
What he did after page 44 was issued, what did he do?
This order of
After page 42 was issued, what did he do? Anything during his lifetime?
my lord, he was this was my lord.
After page 42 was issued, did he do anything during his lifetime?
No. My lord,
Obviously, he doesn't want.
he
You
incapacitated.
cannot raise this claim.
My lord, he was
Only
simply-
he could have raised this claim that give my son or my ward a compassionate appointment because I am incapacitated. He was not incapacitated. He was unwell. He says, I'm not able to perform properly. He says the department is loser. This is what he says.
My lord,
So let me retire.
my
You
lord,
are unnecessarily paying me
my
money.
lord, to assess my physical incapacitated condition. This
Yes.
has been written in the my lord representation.
Correct. We consider that. You need not repeat. That we have seen. Yes. Yes.
My lord, I have to take instruction, but what I've gone through the brief, my lord, as rightly stated,
nothing.
my lord, that no medical board was constituted to make him incapacitated.
No, he didn't take any steps. He just wanted VRS. He got the
Got
VRS
VRS.
without any grievance. He accepted the VRS. He lived past the age of superannuation. He never raised the grievance. And when he made the first application for compassionate appointment,
Soon after, my lord, declaring my lord giving retirement.
how can you? You cannot.
The right
cannot.
of the dependent, my lord, would come, my lord, after
You
my
cannot. You are not. You have no locus as long as he is alive.
Your lordship knows in the Bindal's judgment, my lord, a voluntary retired employee cannot agitate anything after the voluntary retirement, my lord.
That is, my lord, was the simple case of voluntary retirement. It is not a simple case of voluntary retirement.
What is his date of demise?
No, later he denied, my lord. He was, my lord, suffering.
Why you are not giving the date, sir? We have asked you at least 3-4 times.
Yes, my lord. And
You don't know what the date of your father's unfortunate demise.
yes, my lord. I'm giving. Kindly, my lord, allow me some time, my lord. I find this. My lord, 3rd July 2019, my lord.
And the deed application was made by her in 2014 after acceptance of the voluntary. Yes. I it's a main term.
My lord, they have not, my lord, used in the affidavit, my lord, they have.
Where the dates emerge.
My lord, page 42. By which, my lord, this, my lord, my father was retired, declared retired. The basis of the retirement has not been spelled out, my lord.
Some correspondence from the director.
My lord, with regards to my father's, because the page 107, my lord, indicates that there was correspondence in between the department and department is 17, my lord. Department is satisfied, my lord, that it is satisfactory document on incumbent's plea for VR on medical ground. This is the report as asked for by the department.
Infile disposed. Infile disposed.
My lord, then let me come back, my lord.
This is the two letters written by the director
My lord.
supporting his claim. Based on that, you have accepted the voluntary retirement. What is he saying? Because when he is so ill, maybe he is not able to properly pursue the matter.
Yes, my lord. That is my lord. And my lord, if my lord, page 41, if it is Bengali, my lord, it is written from the office, his father to
You
the.
filed the OA.
Yes, my lord.
You have said that because of illness, my father could not pursue the matter.
My lord,
Where have you said this?
my lord, the right, my lord, after retirement, it comes. My lord, page.
Sir, there is nothing. You say yes when we make an observation. You did
The
not make any
application-
such pleading.
Page 44, my lord.
What 44? We have seen 44. How many times will you see 44?
And my lord, thereafter, my lord, page 45.
Nowhere you have said this fact. You could have stated it in the first representation that you made, that my father is bedridden, he is not able to pursue the matter, therefore I am writing. Everything you can't do standing here. If there is no case made out by your client, what can you do?
My lord, it is-
Anyway, let us see what these two documents are. Let the learned state advocate.
Well, the next attempt, I'm in difficulty.
Before calling,
I'm mapping for the Public Service Commission.
you will land in difficulty only if it is called, otherwise you will be in no difficulty. What happened?
First of all, I could not recognize that the direction to take instruction. Also, they have taken instruction.
I have
Blood.
taken instruction.
Yes, PSC.
Lordship,
What do you want?
Any day after next week, let
As spread any
Thursday week.
in the meantime, as per instructions, you have to file something.
No, Lordship. There was
May
only direction.
I have
take
an advance
instruction.
copy of that report so that I can come prepared?
Lordship, it's only has come to me as an instruction, Lordship.
How
Lordship,
second will-
directs-
If we don't want to look into that, why you give us these instructions?
Lordship, I don't want to give this instruction. He is saying to give him the.
No, then that's
advance
why we
copy.
ask you how you will place it before us.
Lordship, all the verbal submission. I have not received any records, Lordship. If your Lordship so directs, I can file a report, Lordship.
Because we are adjourning it, do it in the meantime. You already have the written instructions.
Lordship,
In the meantime, what is the date of the instructions?
Lordship, it has come through the email, Lordship.
Email doesn't have a date.
Yeah, yes, Lordship.
Yes.
I have to check the.
The learned advocate,
Print out.
I think one of the direction given by a lordship on 30th of March for production of the vigilance manual. No,
Question of
the vigilance manual. My lord,
Sir,
for
this is a single bench matter, my lord, actually.
no, my lord, it's not. My lord, it was filed on 11th of August.
The order, my lord, 19th November 2025, my lord.
My lord, it was filed on 11th of August. My lord, I do have, my lord, it's not, my lord, only thing you actually would take up, my lord, 30th of March order and thereafter 14th of July order. No, Didi, it হবে না, এটা আগে file. My lord, your lordship will find the affidavit, the verification page. That is at page
19th November 25.
19th November 2025, my lord.
There is an order.
total order. Filing slip term করে
The last order.
Well, I will produce, it's better, my lordship grants me 1 day time, I will produce the filing slip. But I do have the filing slip with me, my lord.
She is saying 19/11/25. There is some order passed.
My lord, on that day, my lord,
The affidavit of the writ petition is dated 20/11/25.
2011-25. Yes.
How an order could have been passed on 19/11?
This is a single bench order.
There is no such, cannot be. It's an impossible situation. 1 day prior to swearing of the affidavit also, we passed the order. What is the date of filing? OA?
OA is filed on my lord 11th of August. Verification page at page 32 is 7th of August, my lord, it is verified. 11th of August, my lord, it was filed. And 13th of August was the first date.
Then why it should go before the single bench?
But, last order is 19th November 2025, my lord. Last order.
Can you please read the order?
Yes, application. Hi, yes.
Can you read the order, please?
This order, my lord. 19/11/2025, my lord. That I'm saying.
In this court?
No,
Then,
administrative tribunal.
oh, where is, you have a copy of the order? It is in the brief.
Yes, in the brief.
Which page?
Last page, my lord.
Last page.
Last one, certificate copy part is there, last order.
Last order.
One of the impugned orders.
My lord,
Is it one of the impugned orders?
my lord, this is last order, my lord, I may say, my lord, by which the tribunal became non-functional. Initially, my lord, there is a mere direction of filing affidavit. But that order is not annexed here. But that was the order, my lord.
No, this is an order. Perhaps you are seeking a stay. This is an order passed on MA.
MA, my lord.
Did you seek any relief in this regard?
My lord, I want, my lord, the stay of the criminal case. My lord, I'm not pressing that part. I'm only on departmental proceeding in this application, my lord, basically. As because that was filed before the learned tribunal, everything which was there before the learned tribunal has to be brought before lordship in form of this writ petition, my lord. So that was annexed.
What is the letter of 6/11/25 referred to in this order?
Last order. Page 156. It's not
156.
But this is for lodging an FIR.
Yes, sir. No, that has nothing to do with my pending departmental.
Already lodged.
No, nothing has happened. There was a proposal to lodge an FIR, that was brought to the notice of the tribunal, nothing more.
So what are you agreed by?
The initiation of proceeding, which was done at the behest of the
that vigilance manual, that is why we asked.
Absolutely, my lord.
Oh.
The entire thing was done by vigilance, and my lord, he just signed and filed it. That is the reason your lordship by 30th March order, my lord, asked the state respondents to produce the vigilance manual. Now, on 14th of July, my lord, Learned Senior Advocate Chandra Alam paid time, and thereafter matter was 6th and 5th of August. My lord, on that day, my lord, because of some difficulties, my lord, I mentioned before Lordship, I left the court, and today is the next very day.
Yes, you sought time for complying with the order on 14/7. Your learned senior has sought the time for complying with the earlier order. Why it has not been complied?
Lord, the last day, you see that the order is 19. That is why, my lord. 19th.
Don't say those things. That's much prior to this date when you have sought time for complying with the order.
Then, not today, my lord.
Then not today. What will happen by adjourning it for the day? Is the instruction received?
Next week, next Monday, my lord.
Are you aware whether anything has been received by your office? Let's see if he comes tomorrow then.
Can I tomorrow? Let that be Monday, my lord. Monday tribunal application stays on Monday, my lord. I don't mind, my lord, even tomorrow I will be here. But I'm not as
Today again a prayer is made on behalf of the state.
copy be also served upon me. Is there such a document manual, but it's not available in the market, my lord.
I find it very intriguing.
My lord, it's not available. My lord, I can assure you, Lordship, my lord, I have searched like anything.
Private publisher publishing.
No, my lord, nothing. No.
Government, public publication.
No, nothing. Nothing, my lord. My lord, it is kept as most secretive document. But to be very candid, my lord, I have asked many senior lawyers, very few do have, my lord, which they can get hold of it. Yes, my lord, but this vigilance, my lord, they think them should be a secretive, my lord, something like that, my lord. Well, but this is what is there.
There's one copy with me, but I may assist your lordship by supplying that copy.
Well, very few seniors do have, my lord. I have tried my level best all around, but I couldn't procure it.
I have come with a free book presentation to find on the department. Anyone can download and print it. Plus, the private publishers also they publish. The common feature that normally the state printing is
Here, my lord, that is not there, my lord. Well, his lordship also knowing, my lord, vigilance manual is, my lord, something very, very secretive thing.
Yes, I see that you're passing out of
But this is available in the market, my lord.
by private publishers.
By private, that is available in the market. But this vigilance manual, my lord, even the land reforms manual, that is also available. But this vigilance manual is, my lord, something very secretive.
Executive orders are available.
No, not all. Your lordship is absolutely right. It's not available, my lord. But everything is kept secret, my lord. Sometimes if something happens, my lord, why memo number such and such a memo has been quoted, now you are off. And nobody knows the memo.
Lord, kindly fix it Tuesday, my lord, not Monday.
Seventh.
Seventh.
That's why we said
That's all I will.
February 2026.
What?
না আমার কাছে আছে 11 ফেব্রুয়ারি 26 আছে, I do have the copy.
Yes, call the next.
Number 4. In this matter, I am attending. Case of voluntary retirement.
What is it?
Voluntary retirement
PRS.
on 20th of June,
Accepted or not accepted?
not accepted. But what happens in this matter, earlier hearing was made and your lordship directed in pursuance of the amendment inserted in the
Double A, double A.
double A.
Oh.
Yes, that kindly take appropriate steps so for the health is concerned
Yes.
in terms of the proviso thereto. No, my lord,
It's a special case.
yes,
Why?
because he is suffering from arterial fibrillation.
And he has stated this in his application.
Yes, and lordship directed for filing affidavit and reply, affidavit in opposition and reply. Where earlier state advocate filed one opposition. In pursuance thereof, my lord, I filed the reply. That has been copied and reaffirmed by the present state advocate, and that has been deposited before your
So
lordship.
what have they said about this?
They have said that 75 AA is not applicable in this case, since application was made on 20th of June 2026 and 75 AA was inserted in 2021. Then I am covered by 75 AAA, and that was my case initial.
To which paragraph in the opposition?
In opposition, I am telling lordship. Lordship, can I come to page 5 of the opposition?
It is.
Paragraph Lord XX. At the question of sympathetic consideration of the petitioner's application for voluntary retirement as annexed in the instant list, being annexure P7, page 51 to 52, and annexure P9, page 56, under the proviso to rule 75 AA, WBSR part 1 does not arise or at all, since such proviso has been inserted by notification number 454 dated 1st February 2021.
আপনি মনে হয় ওইটা
ওইটাই তো দুটো একই আছে।
কি আছে কিন্তু পেজটা আলাদা, এটা হচ্ছে পেজটাই তো আপনি আগেরটা থেকে দেখছেন
ঠিক আছে, পেজ 7 দেখাবো, একই তো।
একই কিন্তু মানে এটা এসছে তো।
What is the date of the amendment?
Yes, shame, Lord. This is, Lord, dated 1st February 2021. In their opposition, this is page 5. In earlier opposition, this was page 7. Earlier opposition, that was page 5. Same paragraphs, same statement, same contention.
Your OA is there on record.
Yes, yes. But not on record, my lord.
So you have given us.
Your lordship's direction, my lord. I submitted the copy of the way. Way was found on 21st of March 2018. দিয়েছি আপনাদের কপি সমস্ত কপি একদম ডিটেল
আইন সেপ্টেম্বরে আর সেটি 104
You have filed a reply also.
Pardon me?
You have
Yes, I have filed the reply.
This one. 14. 14. That's okay. You never challenged A2.
Yes.
You challenged it.
A2 means Lord, that insertion subsequently that I challenged, but your lordship took exception to that. After insertion of they previously on earlier occasion they told that 75 AA is there, and because of the reason lordship.
No, your client has suppressed the fact that earlier his application was rejected in 16.
Lord, it was never served upon me.
He has never said this. He has never said this. He's just a blank denial that everything in this paragraph is false.
false means it was never supplied.
We'll consider, he has not
But
said
it is
this.
similar to what I am submitting.
He has not said that it was not supplied. He says all this is false, that's all. He refrains from making a positive assertion that it was not supplied. And even if that is supplied, he has not challenged it. So therefore, there is no question of any relief being
6th
granted.
November 2018, Milord, he intimated with prior notice that from that day I will not attend the hospital.
We don't know under
He
which
didn't
provision.
attend. Then he was in his residence. Then if some letter is sent to Milord hospital, that cannot be served upon him. This is the
We don't know. We will not go on such presumptions. He is guilty of willful and deliberate suppression of a material fact. He had the option in his reply. He has not used that option. We went through the reply. Everything said in the paragraph is false. Wonderful. That is a standard reply in every reply. He never said that it was not served. Now it has been served. I will take steps. Nothing.
then
He is not interested that after it was transferred in 2014, everything became a problem for him. That we are looking at.
Lordship can we leave as a
No, not at all. Not at all. No, sir. This person does not deserve such leniency. The medical officer, this is the way he is functioning, abandoning his hospital duties.
Milord,
We can.
Lordship kindly Lordship kindly consider the prescriptions and other medical documents. The illness is suffering, Milord. Any time he may suffer heart attack, arterial fibrillation. Lordship kindly sees this. I have stated one by one on different doctors have checked up in different hospitals, both government and private. Lordship kindly sees page 36 of my reply. There were a reminder for VRS was there. Even if on 8th of September they had rejected my application. Another, this reminder for VRS, that can also have to be considered. Because since 2021, 24th of March 2021, this was served upon Health Secretary. But since then, 5 years have already gone. I am not taking a single penny from the government.
Not any kindness shown by you. You are not performing your duty.
I intimated Milord.
Not taking money.
Milord, I intimated the authority concerned.
That's not the point.
I intimated the authority concerned that on and from this day it is not possible for me on health ground. Lordship, can you seize the medical documents and then consider?
Challenge is memo 1833. Where is that memo? 1833.
That is an original application, Milord. 7533.
Challenge it in the 1833.
1833.
Please see your prayer in the OA prayer A.
My lord,
Where is it? 1833 FP?
it is here. I have annexed with the application, but I didn't
Which
trace
page?
it.
Which page, please?
My lord, I'm telling. What I submitted, I am not pressing it. '57, my lord. On 877
Of the rate petition?
of the writ petition. Annexed P10.
No, it is not. Yes, second bit, right? C page 17. 99 statements have exceeded. Where is the tribunal order? What the tribunal did?
Pardon?
It was still pending before the tribunal.
Yes.
We have no case, sir. Sorry. We are not inclined to allow this. Heard the learned advocate.
make fresh application in view of the.
That is been
Oh,
granted.
yeah.
We have said that relying on the proviso, if on your health condition, you can do it.
Definitely.
Para 5.
That I appear on.
I appear on behalf of the state.
Hmm?
I appear on behalf of the state.
So far the present matter is concerned,
Yes.
Milord, your Lordship may kindly consider, Lordship may kindly come to, first of all, one document that is at page 79, which is the roster of 50 vacancies. Now, Lordship will be pleased to find page 79. Now, Milord, 14, 15, 16, 17 vacancy. 14th is unreserved, 15th is scheduled caste, 16th is unreserved, and 17 is unreserved. Now, so far the petitioner is concerned, he is a scheduled caste candidate. Now, Milord, I should draw to my Lord's kind attention with regard to one document of the particular authority, Milord. The 50, it starts from page 81, 50-point roster of the superintending engineer. Now, this is, Milord, in fact, a promotion to the post of, Milord, additional chief engineer. I'm grateful to my learned friend. Now, Milord, kindly come to page 83. Now, page 83, your lordships will be pleased to find that, Milord, here, against the respective serial number, the names of the candidates had been indicated. Now, one document make the thing, Milord, more clear to my lords. At page 89, that, Milord, a letter was issued, not letter, Milord, this was an order, if I may say so, with my greatest respect. Page 89, Milord, kindly take the trouble, I'm troubling my lord. This is an order dated 6/7/2022, and in the middle portion, the main thing, Milord, had been indicated that the proposed vacancy coincides with 14, 15, 16, and 17 point of the 50-point roster earmarked for unreserved, scheduled caste, unreserved, and unreserved respectively. Now, Milord, the issue which has come for my lord's kind consideration is that there are, Milord, the four Milord aspirants. Now that again your lordship has to take the pains, Milord, to come to page 83, because I am showing to the court, Milord, about the particular respective candidates. Now, Milord, kindly come to page 83. Now, this particular Chittoranjan Bormon, which appears in page 83, he was, Milord, promoted in respect of the 14 point, which is unreserved. As your lordships have taken note of it, that 14th is unreserved. Now the main point comes is about 15. 15, my lord, if your lordship, my lord, takes into consideration the roster of vacancies, 15 point is schedule caste. And that has also been indicated by the department's letter, that is at page 89. 15 is schedule caste. Now, my lord, now, my lord, okay, একটা দিয়ে দাও এই যে এটা। Now, my lord, the most important feature of the matter is that, my lord, there is a provision of a rule which is known as, my lord, amended provisions of Rule 10B. Rule 10B, my lord, I am handing over to my lords, my lord. I am reading the rule and then I will be saying, my lord, why the 15 vacancy was due to be filled by me. My lord, I would have been accommodated in the 15 vacancy. That your lordship may kindly come to Rule 10B of these amended rules. If a, my lord, has, my lord,
15th vacancy which you are claiming
yes, 15 vacancy, my lord, it was kindly
was filled
considered.
up by which person?
My lord, this was filled up by one Somorendra Nath Das.
He is a party to the present proceeding.
No, the, my lord, I tell you, I just let me check up.
Yes, page 91. You are right. Samarendranath Das has filled up the post. Is he a party to the proceeding?
Yes. Now, my lord, I just draw to my lord's kind attention.
He's a
about
party.
Yes, party. He's respondent number 9. Now, my lord, kindly come to Rule 10B. This particular, my lord, one-page rule.
So what is your grievance? It
That
has been filled up by Samarendranath Das was not due. This post was
no, my lord, I am making a submission which perhaps, my lord, after kindly give me, my lord, 5 minutes time.
Yes.
Now, Rule 10, Sub-Rule B, it says that if a candidate from the scheduled caste or scheduled tribe obtains promotion on the basis of merit with due regard to seniority, his promotion shall be made against unreserved vacancy, and reserved vacancy shall be filled up by selecting candidates from the remaining scheduled caste or scheduled tribe candidates, irrespective of merit, but are within the normal zone of consideration and are considered fit for promotion. Now, I am submitting before my lords that if your lordship, my lord, takes up the case of Somorendra Nath Das,
Yes.
who is a scheduled caste, he could have been fitted in the particular vacancies of unreserved, because he is a scheduled caste candidate. Now, because I say, my lord, that I found that from the roster, unreserved, scheduled caste, unreserved and unreserved. Now, herein, my lord, comes the main thing, and my lord, your lordship will be pleased to find that, my lord, this 15 vacancies, since it was filled up by Somorendra Nath Das, now I could not be accommodated in respect of the particular 14, my lord, points of the 50-point roster.
So if he makes way, you would have got it. That we have understood. That if he is taken as a general, he makes way, you would have got it. Why he should be taken as a general?
No, my lord, I say, my lord, the rules permit that.
Permit is a different thing.
That now,
Does he have the eligibility? There are many things.
I tell you, lordships.
Yes.
My lord, I am grateful.
Even if this rule is not there, this is the law.
That is the law.
Because there is no reservation in unreserved. Merit has to prevail. Anyone of virtue of merit will qualify, will go in the unreserved category. But where is these essential facts?
Now let us come to, Milord, let us come to the particular, Milord, features of the matter that Somarendranath Das was given in the 15 point very well. Now this point also came up to my mind that in any particular establishment, now these vacancies are not static, Milord, the subsequent vacancies also arise or subsequent points in the 50 point roster arises. Now the thing, Milord, which I came to learn, subject to correction, Milord, of my other side, that, Milord, the 18th roster, 19th roster, 20, 21, 22, 23, when these vacancies occurred, my case was not fitted in the particular respective vacancies.
But you have not claimed any relief on that score.
Milord, why? Because this was during
That is beyond
this
the
is
scope
during
of
the
POA.
pregnancy of the
POA, you
principal.
have challenged only 3 documents.
Yes. Now,
91, 92 and page 106.
Now, my lord, your lordship may kindly consider, my lord, that it is well settled, which my lords have laid down the law, that if any vacancy or suppose, my lord, any event occurs during the pendency of a proceeding, court always, my lord, takes into consideration about the particular, my lord, situation and how it affects
So what
the
is
rights.
the date of the panel?
The Miller panel has not been, there has not been, Miller, subject to correction, Miller, there has not been, because this is only a 50 point roster of the superintending engineer.
No,
I
there
don't know.
must have been a DPC.
Miller, I say, Miller, kindly consider.
There would have been a DPC, they would have candidates.
Now what happens is that after I filed the case, they were, Miller, agree with my action as to why I approached the court. Then what it appears, my lord, that they had instituted a particular proceeding against me and said in the report that the departmental promotion committee is considering this particular.
Will not travel beyond this.
I do not go there. I do not go there. I
They are
said
only asking you a simple thing. Why 15 should be placed in unreserved?
because of this rule.
That's all.
This is number one. Number two, Miller, just kindly do not shut me out because
No, we are not. We are asking you why.
because why I say, because if the persons of the scheduled caste category, they are not being considered, lordships have laid down the law that, Miller, the persons belonging to the reserved category, they should be treated in a different way, and it should be ensured that there is no affectation of right of these particular candidates, that is the scheduled caste, scheduled tribe. Now your lordship may kindly consider that, Miller, I have shown to my lords, Miller, the particular rule 10b. Now, Miller, your lordship may kindly consider one thing, that promotion seniority is different from seniority as per roster. This is also another thing, Miller, which has to be taken into consideration.
No, it does not. The only thing is why 15 should go in unreserved.
Right.
Why this Mr. Das should go in unreserved? That's the only thing you have to tell us.
Now, this
You said that the rule is there.
yes,
We appreciate. So what else? You are only relying on the rule or something else?
Milord, I just accepting the rule. I also rely upon something else.
Yes.
So, my lord, I'd be indicating one thing more. Kindly come to page 89 for page 89 will make it clear that a decision was taken for filling up 4 posts. Kindly see the first paragraph. In continuation of this office letter under reference number such and such, I am to inform you that consequent upon superannuation of Dilip Kumar Chattopadhyay, additional chief engineer attached to Asansol Durgapur Development Authority on 30th of June 2022, all 4 posts of additional chief engineer are lying vacant since the proposed vacancies coincide with 14, 15, 16 and 17 point of the 50-point roster earmarked for unreserved, scheduled caste, unreserved and unreserved respectively. Therefore, my lord, it was a decision to fill up all 4 posts. Now, what they did, kindly come to the next page. Page 91. This is letter dated, a notification dated 18/7/2022. The governor is pleased to appoint the following engineering officers now posted as superintending engineer, municipal engineering directorate, on promotion to the post of additional chief engineer, municipal engineering directorate under the administrative control of urban development and municipal affairs department in the pre-revised scale of pay of such and such, now revised under pay structure of the West Bengal Service ROPA Rules 2019 in level 2 plus allowance as admissible from time to time under the government with effect from the date of assuming charges as additional chief engineer and further order. Then, my lord, they fill up only 3 posts. Now, what they do, they segregate for filling up the post to 3 plus 1. Then this is a letter dated 18/7/2022. Kindly come to the next page also, page 92. This is dated 11/10/2022. The governor is pleased to appoint Srimati Sohili Chaudhary, now posted as superintending engineer, municipal engineering directorate, on promotion to the post of additional chief engineer, municipal engineering directorate under the administrative control of urban development and municipal affairs department in the pre-revised scale of pay of rupees such and such, plus allowance as admissible from time to time under the order of the government with effect from the date of assuming charge as additional chief engineer and until further order. Therefore, my lord, one thing which I note, I leave it to the kind consideration of this honorable court, that although they have indicated that these 4 posts should be filled up, but my lord, what they do it in a phase-wise manner. First 3 slots, then 1. Now this একটা পীযূষকে দিয়ে দেবো পীযূষ কোন একটা একটা এটাই যেটা আপনি 10 দিয়ে করলেন না স্যার?
Training in their course.
Yes, yes. এই active, হ্যাঁ, কপিটা active copy, active টা।
ये दादी तुला
ঠিক আছে, বুঝেছি তো। ঠিক আছে, ঠিক আছে, ঠিক আছে, ঠিক আছে, ঠিক আছে, বসুন। Milord, I was only submitting that, Milord, that the actual number of vacancies which they have indicated, that has to be filled up, Milord, while taking steps for filling up the post for promotion. 4 posts. These they cannot do in a phase-wise manner.
That we are working. They have done it after a month.
So how does it prejudice you? That's the point.
Right. Now, Milord, your lordship may kindly, I understand what my lordship may indicate. I'm grateful. Now, Milord, your lordship may kindly consider that
All the promotions have to be considered unless there is something else you are relying upon. On the basis of annexure F,
on the basis of,
annexure F to the OA.
yes,
Where is it? Please see annexure F.
annexure F.
That is the 50-point roster.
Yes, yes,
According to that, there is no dispute that 14 is unreserved,
yes,
15 is SC,
SC,
16, 17 are unreserved.
reserved.
So there is till here there is no dispute.
No dispute.
Now, whether a person will come by virtue of merit or he will need the benefit of reservation is to be decided on the basis of his position appearing in the seniority list of subtending Indian.
Right.
So where is the seniority list of subtending Indian? Either in the seniority list he comes by virtue of his own position, or if not, then he will get a benefit of reservation.
Reservation.
So where is the seniority list of subtending Indian?
Milord, 1 second, Milord, just 1 second. Milord.
No, we are showing you. It's 57.
Page 57.
Yes, sir.
Your lordship has gone much. 50 seconds. Milord, just 1 second.
This is your pleading before the tribunal. You have to still seniority list also of subtending engineer. Now 36 is Chittaranjan Burman.
36 is Chittaranjan
He
Burman.
is a SC candidate.
Yes, no dispute.
But he is the senior most person available for this posting. So against 14, which is unreserved, he has been posted. He has not been given benefit of reservation.
Right.
Next is Samrendra Das. Because 15 is SC post.
Samarendra.
15 is reserved for SC.
Yes,
The next SC is Samrendra Das
yes,
in the seniority.
in the seniority.
So he has shot above 37, 38, 39, and he has been given the reservation benefit and he has been given the 15th post.
Yes,
Now 16th post is given to the next in order of seniority at serial 37, Mr. Kinshuk Rai.
Kinshuk Rai.
And the 17th post has thereafter been given to the person just above you, Sahili Chaudhary, because Tapan Kumar and Chandan Mukherjee have retired.
Yes, they are retired.
So there appears to be no infirmity in this.
Well, your lordships may kindly consider that so far as Chittaranjan and Kinshuk Rai,
Yes. They are both unreserved.
no, Chittaranjan is scheduled caste.
No, but he has got by virtue of his merit
No,
on serial 14. Serial 14 is unreserved as per roster point.
your lordship may kindly come to page 83. Page 83, this is the department's own 50 point.
Yes. 14,
50 point.
14, 14.
This is Chittaranjan Burman. His name is appearing in serial number 36.
Huh?
As my lord got it, page 83.
83. Correct, correct.
Now, the Chittaranjan Burman, who belongs to scheduled caste,
Yes.
has been given in a scheduled caste.
No. He has been promoted against general. Serial 14 is general vacancy.
Serial 14.
Yes, he is at serial 14 on the roster point.
Miller, just 1 second.
Now, how we are saying that, we'll show you. You come to this communication at of 6, 7, 22 at page 89. 14, 15, 16 are earmarked for unreserved, SC, unreserved, and unreserved.
Is referring to Miller, the communication.
Page 89.
Page 89, yes, yes.
Now, see, 14 is unreserved,
14 unreserved,
15 is SC,
SC,
16 is unreserved, 17 is unreserved.
right.
So 14, Mr. Chittaranjan Burman has occupied by virtue of his merit. He is SC candidate. It is unreserved vacancy.
He is SC, but filled up in the unreserved.
Unreserved. So by virtue of merit, he has come.
Yes.
Now, who is the next SC in the order of seniority?
Next, Miller, your lordship may.
Samarendra Das.
No, I say, Miller, here I join an issue. I say, Miller, kindly consider. Miller, kindly for a second, Miller, peruse the particular provisions of the amendment of the Rule 10B.
Do not emphasize. There is nobody can dispute that situation, whether stated in the rule or not. There is no reservation in reserved category. That's a basic law.
That is,
All reserved category can migrate to the unreserved, but other way impossible.
Right.
So therefore, you need not emphasize with reference to any rule. This is the law laid down right from Indra Swani's judgment. By virtue of merit, some may migrate to a unreserved category. But the unreserved category, therefore, Chittaranjan Burman has been promoted against the unreserved post.
yes,
Because he was the senior most, he was having the highest. It's a seniority based promotion.
yes,
So he has come.
yes.
Now, second post 15 is reserved for SC.
Yes.
So who is the next SC candidate?
Miller, in my very respectful, yes, Samarendra Das is a scheduled
Who
caste.
is the next SC candidate?
But-
What next?
But Miller, your lordship may kindly consider. Lordship has to take up the thing, Miller, about the amendment of.
So then 15 should be filled.
Now, Miller, this particular post of 15,
Yes.
that should be filled up in my very respectful submission by the candidate in the Milad, by
Category, sir. That's just what we have said. Migration is permitted by law only one way, from unreserved to reserved, not from reserved to unreserved. That reserved category can be filled up by unreserved only if the rule says that in absence of candidate it is to be filled up, or if the rule says after waiting for 2 years if it remains vacant, something like that. Otherwise, in that transaction, it has to be filled up by an SC candidate. So 15 being an SC post, that has to be given to the next available SC candidate, who in this case, as per the seniority list made by you, is Samrendranath Das. So he has been given the 15th post. Then comes 16. 16 next in order of seniority, serial 37, Kinshuk Roy.
unreserved. Now, Milad, even your lordship may kindly consider that as a scheduled caste category candidate, I could have been fitted in the unreserved category
You cannot.
because of that amendment of the rule.
You cannot. Unless you come by virtue of merit, it is not that you will be picked up and put in unreserved because the rule says.
I am submitting, kindly see this particular list at page 83. Chittaranjan first, Kinshuk is second. Then, Milad, this Tapas.
Forget about 38, 39, they have
Yes, they have
retired.
retired.
Yes.
Now, then one Somarendranath Das,
ST.
Sohili and Paritosh.
Correct.
Right. Now,
You can only be considered after these posts above you are filled up. Before that, you cannot be considered. You cannot be. Because by virtue of if you were at serial 40 in the seniority list, then perhaps what you are saying you could have, it would have been considered. But you are not. You are below even this last person who has been given the promotion by way of a separate notification.
no, that I say, Miller, that this cannot be done. This promotion, 4 posts, they have been chosen to be filled up at a particular, Miller, in the same pace, or Miller, at that particular point of time. Now, the phase-wise promotion from 3 and 1, from 4 to 3 and 1, 3 plus 1, this I submit that this is impermissible.
We don't know how you can raise this issue.
Miller, why your lordship may kindly consider this?
That's why we ask you, what is your prejudice? How it affects you?
I just Joseph get tweeted this. Miller, I have this is
So basically, you are challenging a promotion given to one Srimati Sahili Chaudhary.
Shaili Chaudhary.
Yes, she is also a party. You are sought question of this notification of 11/10/22.
11/10/2022.
You have sought question of that.
Miller,
In the
let
OA.
me check up.
Otherwise, this exercise will be a pointless exercise.
Yes. Washing.
Quashing 11/10/22.
But lordship may kindly consider that in the column of explanation, যে সমরেন্দ্রনাথ দাসের পরে আপনার ইয়ে আছে।
কিন্তু স্যার চারটে নিজে সমরেন্দ্র দাস তো নর্মাল সিনিয়রিটিতে পাবে।
তার ইন দ্য শিডিউল কাস্ট পার্টিকুলার ক্যাটেগরিতে সে তাকে দেওয়া হবে।
কেন দেওয়া হবে স্যার? যদি নর্মাল সিনিয়রিটি থাকবে না, রিজার্ভ হয়ে যাবে। বারবার স্যার আপনাকে
সেটা তো আপনি বাই রেফারিং টু দিস রুল
হ্যাঁ,
10B
রুলের
জজ সাহেব সেটা বলছে, আমি এটা ধরবো না।
কনস্টিটিউশনের রুল না মানে
আরেকটা কথা বল,
আপনার চারজনকে একসাথে নিতে হবে, এটাই নিয়ম স্যার।
Kindly see, I have handed over to my lords, my lord,
Yes.
one particular, my lord, rules, my lord. This is the scheduled caste, scheduled tribe reservation rules. Here, my lord may kindly consider the explanation clause. Normal zone of consideration in respect of promotion to any particular post or posts shall consist of such of the employees eligible for promotion to such post or post according to the prevailing recruitment rules or procedure as occupied when arranged in descending order of the seniority 5 times the number of vacancy or vacancies actually available for filling up by promotion at the time of consideration. Therefore, I very respectfully submit that actual number of vacancies which were subsisting, that has to be taken into consideration. But this was not done. This 4 was not taken into consideration, subject to what falls for my, because I have checked up that I find, my lord, that by the notification of 18/7/2022, they have given at page 91, they have given 3 promotions, and then on 11/10/2022, they have given 1 promotion.
So how all the candidates were not considered, or how it is not in order of merit or seniority?
No, I
This
said,
explanation that you have read
yes,
does not mandate that it must be done by one notification. It says such of the employees eligible for promotion shall be considered. It's not your case that they have not been considered.
no.
You said it should have been considered like this instead of this. He should have been given in the C
No,
category.
I have a limited submission. I say, my lord, with the greatest of respect and subject to what falls for my lord, that these particular, my lord, provisions of the amendment of the West Bengal Scheduled Caste and Scheduled Tribe Reservation of Vacancies in Services and Post Rules 1976, under Rule 10B, again I repeat, that if a candidate from Scheduled Caste or Scheduled Tribe obtains promotion on the basis of merit with due regard to seniority, his promotion shall be made against unreserved vacancy, and reserved vacancy shall be filled up by selecting candidates from the remaining scheduled caste or scheduled tribe candidate irrespective of merit but are within the normal zone of consideration. So, my lord, this, in my very respectful submission, subject to kind sanction of my lords, this possibly had not been done. Not possibly, my
It
lord, I
cannot
should-
be. We cannot proceed on possibilities.
No, I cannot, I do not say this has not been done, not possibility.
No, that's what we are asking you.
Why?
How
Because,
it is not being
why?
done?
Because the,
How you are going to prevent any reserved
I
category
am being
candidate?
prejudiced, or I have a right on the ground that first of all these 4 vacancies.
Right.
That somehow this method is superior. This Samrendra Chaudhary is superior to him. Yes.
Now, my lord, kindly consider that this I only thing which I would be again, my lord, indicating that actual number of vacancies, this splitting, my lord, let them, my lord, justify. I am a statutory authority, therefore I can do anything which I like. That I say that 4 post has to be filled up, then, my lord, there was a splitting, and we have a power to do it. I could not find that. I say, my lord, I did not find that. I should be candid to my lords. And the other thing which I would be indicating to my lords, my lord, that as your lordship was indicating, that whether adherence of it, because if 14, 15, 16, 17, I fill up, then may not this particular, as I had indicated, that this person, he gets a right, or rather Somarendranath Das will not be, Milord, non-suited of his position from getting a promotion. I am not saying that non-suit him, but equally I say that as I am standing in the particular this list, my case should be considered. It is not, Milord, that I have a animosity with the department, but Milord, it is equally true, Milord, that I have a right of consideration for promotion according to the rules.
But your entire right is founded on shifting of Samrinder Nath Das
Yes,
to the 14th vacancy.
15th.
14th. 15 is SC anyway.
Yes, I'm sorry.
So you
Milord.
want to throw out Chitranjan Barman, who is another SC candidate. For what reason?
No, I do not. I have no grievance against Chittaranjan.
But if he does not make way, then how this Samrinder will go to 14? He is occupying 14 as an SC candidate.
Kindly consider that as to whether my right can be non-suited in this way. I say, this is a Milord, with the greatest of my respect, Milord, I submit that this is only thing. And only last thing, Piyush.
My lord is
No, we thought you were over. Sorry.
No, I have finished. I have nothing more to, Milord, say, because, Milord, only one thing, though this is not part of this matter, but I have taken the instruction from my client that the 18, 19, 20, 21, 22, 23 vacancies, these have also been filled up. And there also I was not given the particular.
That is not here, so we'll not go on.
No, I say, Miller, I leave it to the court, but because I am just indicating that.
We confine to the relief here.
No, that's all. I cannot say beyond that.
Yes.
Lord, I answer the second, Lord, issue raised. All posts not filled up altogether. Lord, kindly see page 85. Lord, this is 14th December 21, when
Yes.
only 2 vacancies were declared. 14th and 15th. Page 85.
Yes.
Lord, the third last paragraph, my lord would find 14th and 15th.
Yes.
Now, my lord kindly comes to, my lord, page 87. Lord, this is 31st of May 2022.
Yes.
31st May 2022. My lord.
Now 3.
My lord.
Now 3.
Now 3.
In the third paragraph.
My lord. Now, my lord kindly sees, my lord, page 89, 6/7/22. My lord, in the second paragraph, my lord, 4. So this is in a phased manner that the vacancies are arising and the proposals are being sent. On 6th of July 2022, when this is being sent, my lord, the first phase, my lord, and the second phase are already complete, because 8th July 2022, this is 6th July, when the fourth vacancy, my lord, is being proposed. Insofar as the previous 3 vacancies, on 8th July, my lord, it is already, my lord, directed, it's already, my lord, filled up. My lord would very kindly, my lord, come.
Not 8th, 18th.
18th.
Not 8th.
18th.
It is after that date. It's hardly material. If at all there is someone who will have a grievance, it may be.
And my lord, there cannot
be Chaudhary that why I have been considered 2 months late.
My lord. And my lord, there is no mandate. My lord, no law says that the government must fill up all the vacancies. My lord, cannot keep vacancies, my lord, unfilled. There's nothing. This is in phased manner. This occurred, and the moment the proposals come, they have been acted upon.
Even if it was done together, how he would gain, we are not.
I do not know.
Yes, take down. Heard the
Your Lordship wanted that query. I came at a later stage of the
Anyway,
proceeding.
that's not here, so we'll not go. You are for the respondents.
I was
Yes.
waiting for 12:30, I think. 12:30 p.m.
Mr. Chaturvedi was appearing with.
My lord,
Who is for the private respondent?
My lord,
They are not
state,
present.
my lord, led by Mr. Chaturvedi.
Oh, you are for state also. तो 12:30 वाला कॉल करो फिर बात करें.
Madam 47.
We are keeping it on at 12:30. Yesterday you were not here.
the business of the court, my lord, did not permit, my lord. The long matter, my lord, was continuing.
No, yesterday it was very short, but nobody was here.
Yesterday it was called.
Everybody thought that it was long. The day before yesterday. Yesterday we did not sit.
Day before yesterday, my lord, perhaps the matter was called on afternoon. Afternoon.
Yes, because we missed in the first half, and since time was fixed, we wanted to call it.
It started 4 p.m.
What is it? The proceeding
It
matter?
is, yes, disciplinary proceeding.
Not today. When should we have it? Tell us.
Because he has concluded, I am to respond to the only 2 points.
Before this bench?
Yes.
Yes.
Before this bench. Milord, I am to respond that whether, Milord, the Shastri Award part of a bipartite settlement, whether, Milord, my case should have been tried by the Industrial Tribunal or the High Court, and, Milord, the delay also. It is also a part. I said, Milord, that my job that was entrusted with, I was entrusted with a job which is absolutely a supervisory nature, and some clerks are also working under me in my
Sanction of loans.
No, it is, that is a different matter. Grameen Bank. Here, Milord, what happened? Milord, opening of a bank account, Milord, verification. Milord.
Changing of the
Changing of-
introduction.
Yes. Mr. Taposh Banerjee, Milord, was, yes. My lord has a photographic memory.
No.
Yes. Finding fault with
We'll
us.
have a tough time.
Very tough time. After pronouncement of the judgment, his lordship has pointed out there was a show cause. Very tough job, my lord. Stumbling block. Allow us to survive. No, according to your lordship's convenience, any day. Tomorrow possible? Not possible.
Then
I am to answer, my lord. Yes,
We'll pass an order if we adjourn it tomorrow, if it is okay with you.
tomorrow at 12:30 is possible because
yes, I do not have.
10:30.
Item number 1.
Item number 1, I'm appealing
Two.
for the,
Appeal filed by my learned friend and one appeal filed by me.
on the last occasion, my lords were pleased to direct me to file a short list of dates, my lord. I have brought it. May I, my lord?
Hearing almost was completed, only lordship was directed to give my lord.
একটু দিয়ে দিন।
Okay, then
হ্যাঁ।
Why there are two dates of death?
My lord, it is, as per my understanding, it is wrongly recorded, my lord. It needs to be corrected.
So which one is wrong? Probably 10th October is
Is the
wrong.
wrong one. Yes. My lord, I thought I should mention here because it was not mentioned before the honorable single bench also, my lord.
So the correct date is 21st October 2000.
My lords, my lords.
So there is no attendance from 6 to 12.
My lord.
That is your case.
That
From where you have said this?
My lord, in my counter affidavit, I have mentioned it, my lord.
Let's see.
My lords want to consider? Yes. But my lord, last date, my lords were said since it is not mentioned in the appeal, it is not one of the ground, but it is apparently appearing in the writ petition, my lord. It is a fact. It is an established fact. But I am not
Whether this ground was urged before the tribunal.
No, it was before the honorable single bench, and thereafter
Before the single bench, it was.
My lord, that day it was not heard. It was mentioned that this is covered under Maya Bauri, and judgment was passed. Not even a date of hearing was done, my lord. That was my primary grievance. That let the matter be heard, at least the details be recorded. My lord, kindly sees the date of death is also wrong. My lord, that is my case in my appeal. That I was not heard, and this representation in 2025, it was also not considered. Right after sending the representation, they filed the writ petition, my lord. That was my case.
Petitioner is son.
yes, my lord. My lord, petitioner is the widow.
Widow.
My lord, kindly one page, my lord, I shall refer.
Just give us. What is it? Okay. This work is done for what period you have performed this work. September 2000. This application has said from August 2012. There are two applications having 65. This is by himself. What is the date? Illegible. E4. What is the date of this document?
Hello.
Date of this document, page 66
On page of 66.
of the stay application.
Yes, fine.
Yes, ma'am.
This document
Page.
submitted
Yes.
date.
My lord, this document has been my lord, disputed because there is no receipt, my lord.
Date. 12 October 2012.
12/10.
Yes, my lord.
Ah. There is a receiving in the left margin. Has gone inside the paper book. It is, you have stitched it inside the paper book. It's not possible to see.
This is not my paper book.
Yes.
Paper book. My lord, this is the original read petition, which my lord, lordship can. My lord, I'm sorry, my lord, there is a mark.
It is received.
Left hand side there.
Please examine and do the needful.
Deputy manager.
After this, he was not allowed to join.
No, thereafter he died. My lord, died on 21st of October 2012.
Just within 10 days.
This is unfortunate. This is absolutely unfortunate case.
See, they are denying that document was. Hmm. I've seen that. And where is that fitness of 29/11/2006?
Lord, that documents
Not there.
That documents not with me.
Yes.
May I, my lord? Generally, when one disease is detected and Khoraki is given, it is from the hospitals under the authority. And thereafter, once somebody gets cured, they get re-examined and fitness certificate is given. Thereafter, they join the duty. My lord, here the doctor is not from the authority, and thereafter he didn't join.
Which
My lord,
doctor is
this
not?
The doctor's name, as mentioned, inform my family doctor M.K. Pandey. My lord, second paragraph, fourth line, my
That's
lord.
all. He has not written anything more.
The doctor seeing my condition and immediately diagnosis and declared me TB disease on 14/12/2005 and under treatment. My lord,
That's all.
No, my lord.
Nothing after that.
Yes, there after
What is
that.
it? Read.
Yes, yes. And I under treatment from 14 12 2005 to 18 11 2006. Lastly, he declared me fit to join duty in 29 11 2006.
Correct.
Should I continue, my lord?
Yes.
After my recovery, when I was coming to report the same dispensary, office of the personal manager, so and so, with submitting all medical papers, those period. Further, like to inform you, I have several times attended your controlling office, but not response the joint duty matter, and also been 1 year past at the time. My miserable condition could not purchase food, diet, maintain my family, besides studies of my school of my child. This time I bound to do daily labor work of building construction at so and so. Unfortunately, one day of work time, suddenly my injury of back position on 11/5/2008. I was quickly bearing my family members. They are took to the family doctor M.K. Pandey near working place. It was under treatment from so and so 2008 to 2009, and the said doctor advised me to take full rest till recovery. Lastly, on 30 September 2009, fit to join in my duty. Recently, I am suffering from serious disease, hydrocele infection, and have been admitted to CH Kalla. 25th June 12 to 9th of February 13 na Kira? 2013. Sorry, Malak.
Trying to go take it. I understood. We did say that not only the location.
Yes. What is your case?
Well, my case is my matter was not heard. This is my plea in the appeal. My matter was taken up, and the facts. First fact is the representation was made, and 12 days thereafter the petition was filed. So, not efficient time was given to consider the matter. The representation should have been considered first. Thereafter, whatever the reasoned order was, it could have been challenged, my lord. That was my first case. Second, my lord, 2014, that document, there is no receipt, my lord. Page 65. My lord, there is no receipt. That document, my lord, if sees page 65, there is no receipt. My lord, but right at the 67th, there is a receipt. My lord, at the bottom left. My lord, so right after the. Sorry, my lord.
Repetition.
My lord, I have. My lord, the delay has not been explained, my lord.
Delay, why they came to the court after so much delay?
My lord, why they bothered to make a representation after so much delay, firstly?
After how much delay? According to you, this delay is from
13,
which date?
13 years, my lord. 13 years.
Years from which date?
From the date of death. the first representation made after 13 years, my lord.
Which one is that according to you? Which is the first representation?
My lord, page 67 is their first representation, where it is being mentioned what are the reliefs they are seeking. My lord, there is a.
And why you are denying page 66?
My lord, it is not. It was not denied. It was not considered. No scope for consideration was given. 12 days after this representation, writ petition was filed. Just after 12 days.
What is it? They will not receive. Date of death is October 12. Yes. What she has to say about page 59.
What is the answer about 59 is concerned?
Yes, my lord. May I answer, my lord? Generally, when one of the employees die, my lord, that time one information regarding death is required for striking off the name or that purpose, my lord. Thereafter, there are procedures for making applications under the scheme NCWA, my lords, and thereafter they make formal application. That I need, my lord. May I explain?
So you want us to review our earlier judgment that application is not required?
No, my lords.
Madam, please.
No, no,
cannot reopen that issue.
no. May I?
And we will not do it. It is our judgment. We have held that it is not required. Once an intimation regarding that you have received this NCW, it is like a settlement under Section 18 of the RBI Act. It is only on you. You will make an application, then you will make a payment. He is a water loading coal in the underground mine pit. And you expect everything to be done on pro forma. And we are going to do that same thing again.
My lord, I am not on that.
You are on that. Yes, application was not made. We have held application is not required.
Is not required, my lord.
Then where is the question of application?
Two options, my lord. Two options.
Yes.
One is compassionate employment.
Where about? We are not on that. He is only claiming this MMCC benefit.
But as per their writ petition 2014, they applied for employment.
Madam, why you are raising irrelevant issues? We don't know. He has a claim from MMCC, the learned single judge directed to grant it from the date of death. You said application we are asking you to give a comment on page 15, which is the receiving of your employment. Back in 2012,
yes.
You must have seen this history yourself for the first time in 25. Why should you make such a submission?
If my lord,
you are an employer, you have entered into an agreement with them for this socially beneficial scheme, and you are raising such issues in a court. Contrary to the record.
My lord, I am accepting that it is received, the debt is.
You are not accepting. For the first time in 25, he made an application. Where the record shows a receiving of 2012. 13 years prior to.
My lord, kindly grant me 30 seconds. I shall explain. Once.
Please make whatever submission you want to make. But conform yourself to the records.
My lord.
This kind of submission is not going to argue that you are receiving and you say 13 years later. You have to make a submission. We will go through the records. Why you should make such a submission?
Kindly allow me to.
Try to just pull a fast one. That we don't like.
My lord, I shall confine myself with page 59 only.
Very unfortunate submission.
Well, kindly allow me to explain.
We have been allowing you more than 30 seconds. We expect the submissions to be grounded in the records. And we want to rely on what you are saying.
I shall take only 30 seconds just to explain how it is processed. Nothing else, ma'am.
We didn't ask you how it is processed. We are asking why didn't you pay once you knew he was dead?
Because it was not mentioned what benefit they want, whether employment.
You should have an application.
Yes.
Yes.
That is the reason.
The reason.
An application is necessary.
Unfortunately, we have not been saddling costs on you. And in every case, you are arguing the same thing. That is the most unfortunate part.
Lord, kindly pardon me. That was not my intention.
Huh?
That was not my intention.
But madam, you are arguing exactly the same thing which we have decided just few days back or few months back. So many cases we have disposed of in light of that judgment. You through another council have come and admitted to it that yes, we will do it. And today again you are arguing regarding an application
My lord, I
dealing with such underground locals.
I bow down before my lords, but they have to make an application for choosing what they want. They have to. Otherwise, they cannot. We cannot assume that what benefit they want.
And if you would have asked for a compassionate appointment, you would have given him that very same day.
My lord, it would have been processed. It is
Process.
processed.
You are supposed to give him under the NCWA this MMCC right from the date of demise.
Yes.
Irrespective of whether subsequently you give him a compassionate appointment or not. It is not that he will not get a compassionate an MMCC if he has applied for a compassionate appointment. Till such time you give him a compassionate appointment, will he get an MMCC or not?
No.
No.
There is no scheme
Wonderful.
providing both of the facilities to.
Did we say both? Did we say both? Did you say no?
My
Did
lord,
we say both?
my lord,
We didn't say both. We said till such time a compassionate appointment is granted, will you give him MMCC or not?
no.
You will have
MMCC is
to.
granted once there is conformity that they will proceed with MMCC only. If one person is given compassionate employment, there is
Anyway, we are not going to reopen all these things.
Yes.
Everything you have touched it,
view on that.
and we are not going to argue these things now.
My lords, I shall not. My lord, I shall not disturb. Only the procedure.
Very well. Heard you. Party have been heard.
Deeply blessed.
Item number 3.
3. May I take back my read petition or my lord? May I take back my read petition copy or my lord?
Oh yes,
Will
you
be
can.
remain.
We should have it. We'll give you on the next date.
Yes.
Trust us, we'll give you on the next.
Absolutely. Okay.
Lord, the appeal arises in this matter, my lord, I have not received the affidavit as well as my lord. Sought for to the affidavit, my lord. If you say not to my lord, it is otherwise it is recorded in 6th August, as you can see.
affidavit file করিস
This year also showed on 6th August.
Let him verify. He is verifying.
Last date I have already given Millard. He's saying no. Let me proceed Millard. In the court দিয়েছিলে?
না,
Yes,
Give us the receiving. Give us. That will put it to rest.
আর কি করবো বলো আমি? It has to be heard out without affidavits. But I can't say Millard. দিয়েছিলে কোর্টে ওনাকে? affidavit কপি আছে? তাও আনো। Well, let us proceed without affidavit. I do not know. Can't go like this. Ever-ending process. Millard, this is an order, Millard. Judgment and order of 10th of December 2025. তুমি যদি কপি ওকে দিতে চাও দাও, অ্যাফর্ম করেছো, কোর্টে ফাইল করেছো, কিছু যাও না তুমি। Millard, the matter relates for compassionate appointment of Millard the writ petitioner, Millard, whose father died on 9th October 2022. Now, Millard, so NCWA 9 is the relevant NCWA. Millard, initially, Millard, in the records of Millard the company, coal company, Millard, his age is recorded. It has to be when the person enters into a service, Millard, or in a subsequent point of time, he has to give a declaration of his age, his wife's age, and if he has spouse's age, or Millard, if he has Millard dependent son and daughters, that age is given in not once but twice. That is not challenged, Millard, during the lifetime of the employee. Millard, he applies after the death, Millard, which is Millard 21st of October 2022 for compassionate appointment.
And we missed the date of unfortunate demise.
Date of demise is 21st of October 2022.
Oh, that is the date of demise. An application?
Millard, the application is made. Millard, just give me 1 minute, Millard. The application which is rejected, if your lordship takes Millard, I just straight away show the application. Millard, annexure P3. Millard, his application is Millard page 47. Is dated 1st of December 2022, page 47 of Millard the appeal papers. Millard, that's Millard 1st of December 2022, page 47.
Son. 1/12/22.
Yes, it's Millard 1/12/22. Now, Millard, that is rejected by an order of Millard 2nd of September 2023, holding that he is more than 35 years.
He's not?
He's age bar, more than 35 years.
More than 35?
35 years. That's Millard, the order which is at page 40.
As on 21/10/22.
Yes, Millard, that is said. Millard, because Millard, I rely on a declaration given by the father, not once, twice. May I just place page 48 once?
That's the rejection order.
That's the rejection order. This has reference to a letter dated such and such, 7/12/2022. To the deputy manager such and such, Bullieri, and subsequently application nil dated 1/12/2022 regarding the above mentioned subject which you have nominated your son Mukesh Bhuiya for dependent employment in place of the deceased husband. In this regard, you are kindly informed that as per our records, the age of the nominated son is 8 years as on 5th of August 1992, which is more than 35 years as on the date of the application. Under the circumstances, your application providing is nominated to the son in lieu of death is cannot be considered as per the rule of the company. Now, Millard, that is rejected. This is not challenged.
So this overage is with reference to application date. Is it with reference to the date of demise also?
This is Millard. I'll come. What is to demise? Still, he is Millard, barred Millard, because I'll show the document.
No, are you sure? Have you examined it from the date of demise also?
I have checked up Millard. If that date is taken,
he is 35 on 21/10/22.
Yes.
He has crossed 35.
Yes, he has crossed that. Millard, I'll give the calculations, Millard. Nothing. Now, Millard, he also accepts, Millard. This is the position in law. Millard, page 48 is not challenged in the writ petition or Millard any subsequent proceedings. Now, my lord, he files, my lord. Thereafter, my lord, there is, my lord, a rule says, my lord, if there is a discrepancy, if he wants, my lord, to be checked out or, my lord, further ascertained, he has to make an application for re-verification, my lord, because at page 49, the mother writes, that's the spouse, right? The mother of, my lord, the writ petition at page 49, that her husband was basically a drunkard. So, my lord, he has signed, he has put his thumb impression. That is not the correct age. Please send it to the medical board in question. That is page 49.
It should be 3.
Lordship, page 49.
3 instead of 8.
3 instead of 8. He is a drunken, he has written that. But my lord, during his lifetime, there is no correction sought to be made. During his lifetime also. My lord, I could have understood, my lord, during the father was alive, he went back and said, my lord, they have never said so. So the record remains. That is, my lord, page number 49, that is her hard stand. Now, my lord, it was referred under the rules, there is a medical board. I have to refer it to the medical board. The medical board has, my lord, application is at page 40. If you are page 50, if your lordship takes page 50, my lord, report of the medical board, if your now lordship will straight away come, my lord, medical board, as on page 53 is the report, says, my lord, it's 35 to 40 years, my lord, as on the date of the report. So if your lordship takes the death, 35 to 40 years. Now, my lord, he comes to court.
35 to 40 on the date of demise.
So that is, my lord, he is saying, my lord, age assessment 35 to 40 years. That is what they have given, my lord. Now they come.
Page 53.
Page 53, my lord.
Age assessment between 35
present age, naturally, my lord, he will write his present age as per him. He has a present age. Now he goes, my lord, for my lord, basically, my lord, for medical testing is 35 to 40 years.
On the date of testing in 24.
24. Now, my lord, a writ is filed. The first order is
So
not
in
challenged.
one case, we saw that there is a higher board also which reassesses if there is a dispute.
Here, my lord, how it's, my lord, our rules and regulations, a policy decision of the whole India, my lord, which we follow, my lord. It's a policy decision given by we follow it. My lord, there's a medical board who examines and finds out.
No, no, there is a higher medical board also.
There is a higher medical board.
He was appearing in that case.
But that is subject to fines, rules, my lord. Then the person who is equipped, he is to apply. And within 30
So they did not dispute.
No,
they did not dispute.
No, not SSKM. There is a higher medical board in this.
Yes, my lord. In this case, this is not the case, my lord, of going to the higher medical board.
So there is a forum, but they did not avail that.
Go there, my lord. They come to High Court. High Court, my lord, sends it to Bardhaman, my lord, Bardhaman Medical College. They find, my lord, the age is from 37 plus minus 36. Hence, my lord, eligible, my lord, and my lord, compassionate appointment is given. My argument, my lord, is threefold. A, the initial order of rejection has not been challenged in the proceedings, which I reject. B, if there's a provision for medical board, and the medical board finds that he is time barred, or my lord, he is age barred rather, then my lord, can the issue be reopened here? My learned friend will of course argue, look, the High Court has appointed, has passed an order permitting Bardhaman Medical College to assess your age. You have not challenged that. Now, lordship knows, my lord, our writ rules, Code of Civil Procedure applies. Now, my lord, all orders need not be challenged. These are the interlocutory orders. Discrepancy of the order will be challenged in the final order. Every order I need not challenge. That's the interim order. What judgment it decides? It says that please verify the age. That will not even be applicable, my lord, as per, my lord, clause 12 or clause 15, my lord. So, my lord, this is the short point. If your lordship takes, my lord, the impugned judgment once, my lord. Now, in the meantime, what he does.
So you said three grounds. First ground is initial order not challenge. Second
Yes.
is issue cannot be reopened. What is the third ground?
My lord, third ground issue cannot be reopened. Not. I say the second issue, medical board, that issue cannot be reopened by the writ petition. And the third ground is, my lord, that, my lord, whether, my lord, the records of the company, of the, my lord, coal company can be corrected, my lord, after the age, my lord, of a person who was, my lord, in employment. Can it be done, my lord?
So in a sense cannot be reopened.
Can it? That is covering, my lord. If your lordship, my lord, for such purpose, lordship will kindly have a look at the impugned order, which is part of the memorandum. And, my lord, the point, yes, my lord, compassionate appointment is not a right. It's under, my lord, NCWA, one gets this. One has to fulfill the criteria, then he gets, my lord, this right in question. Now, my lord, kindly takes, my lord, matter relates to, very short order, matter relates to its order of judgment and order of 10th of December 2025. Matter relates to appointment of the petitioner on compassionate appointment on the ground of the petitioner's father died in harness on 21st October 2022, who was an employee of Eastern Coalfields. Submission is made on behalf of the petitioner relying upon the medical report of the medical board dated 15th October 2025, which is available on record. As per the medical report dated 15th October 2025, the age of the petitioner was in range, and it was stipulated in the report that as date of the medical examination of the petitioner, that is 15th October 2025, his age is plus minus 38. So, Millard, he is within that limit. That is, Millard, an examination done by court. It is further contended on behalf of the petitioner, if the age of the petitioner is considered to be 36 minus 38 minus to 36, the petitioner comes within the zone of consideration in terms of the age being considered for appointment on compassionate ground. It is admitted the upper limit for providing appointment on compassionate ground in terms of the relevant scheme is 35 years on the date of the employee. The father of the petitioner died on 21st October 2022. The question arose whether the petitioner was within the upper age limit of 35 years at the time of death of the employee. In support of the case made out in the writ petition, reliance is based on a judgment on such and such relating to fixation of age of the candidate based on the medical report was not interfered by the Supreme Court. Millard, I have nothing to say because that case, Millard, the records were not. The records were something different. He produced something different. Service records was not an issue. On the contrary, the learned advocate appearing for such and such has made submission against the claim of the petitioner seeking appointment on a compassionate ground. It is further urged that on date of the employee age of the petitioner needs to be assessed on the upper age limit, as there is no specification in the medical report of the medical board dated 15th October 2025 relating to the age of the petitioner, and it was opined that on 15th October 2022 age of the petitioner was within 36 to 40 years. In order to adjudicate the issues involved in the writ petitioner, court needs to consider the medical report dated 15th October 2025, prepared by the medical board constituted by authority of Bardhaman Medical College, Purva Bardhaman, in terms of the order dated 26th August 2025, passed in the writ petition by a coordinate bank. It is submitted that no appeal has been preferred by the respondent authorities against the order dated 26th October 2025 of the coordinate banks. Therefore, the exercise carried out by the medical board ought to be given credence in assessing the age of the petitioner. In the medical report dated 15th October 2025, no specific date was possible to be recorded. Kindly make a note of it, as the date of birth of the petitioner or the exact age was not provided, but the range of the probable age of the petitioner, which is 38 plus minus as on 15th October 2025, being the date on which petitioner was medically examined. In order to constitute the probable age of the petitioner, the death of the father, the court finds apt to rely on paragraph 24 of the Purnima Singh Supra, wherein the Honorable Division Bench decided issuing considering the age of the respondent lower side as per the medical report, since it is not possible to derive the exact age of the petitioner on the death of the employee, relying upon paragraph 24 of the Purnima Singh, this court is inclined to consider the lowest possible age of the petitioner in terms of the medical report dated such and such for deciding the right to consider for compassionate appointment. It needs to be recorded herein. The ratio of Pune was tested before Supreme Court. Para 9, accordingly, court directs the concerned authority of ECL to process the application of the petitioner seeking appointment on company considering the age of the petitioner 36 years as on 15th October 2026 and the decision taken in terms of the extent rule. If he is otherwise eligible, he will be given. Now, my lord, first question is, my lord, can a writ court, my lord, correct, my lord, the service record, my lord, after the death of the father? That is as per my service records, which lordship will see the service records. Annexure C, page 60. If your lordship takes, these are, my lord, part of the service records in question. If your lordship straight away now come, page 62, which is a document of 1992, my lord, kindly have a look at. My lord, page 63, Mukesh Bhuiya is 8 years. Page 63, Mukesh Bhuiya, date of birth is not there because the illiterate, my lord, is written, my lord, 8 years. If your lordship now takes the second document, which is one another form, Mukesh Bhuiya, 1984, 5/8/1984, which is accepted.
What is the date of this? Form PS3?
Yes, this is, my lord, filed, my lord, with, my lord, the ECL authorities, my lord. This is, my lord, filed 29/5. It should be, my lord, 98, my lord.
29 or
92. It should be 92.
Ah.
So, like 84, 94, 84, 94, 2004, 2014, add 5 to that, 2019. So this service record, my lord, can it be corrected after the death, my lord, in question? My lord? There are not one document, two documents. This has been signed, not signed, my lord, thumb impression by the mother's case is that, my lord, he was, my lord, a drunken man. He has put his, that he never, my lord, was disputed during his lifetime. This has never been disputed. Huh?
It does not say that.
That's the case, my lord. So, my lord, I could have understood, my lord, there are cases, my lord, service records can be corrected, my lord. In service jurisprudence, just before superannuation, you cannot do that. Here, the person is not there and he has given a certificate. He could have given that during, if he had this. Page 37, lordship kindly comes. A birth certificate of 2013 was never 2000, page 57. My lord, it's the birth certificate of Mukesh Bhuiya has been produced, but it was never never produced, my lord, during the tenure of the employee. It was never done.
What is the date of this certificate?
It's, my lord, 24/5/2013. Death has happened in 2021.
No, 22.
21st
21st October 22.
So, my lord, if this was there, natural conclusion is to give it to the, my lord, colliery, my lord. The records would have, today, my lord, this has surfaced. After death, after, my lord, I am not saying, my lord, as I have heard, my lord, what lordship says, there's no application necessary. You have to pay whatever compensation. This is, my lord, employment in lieu of compensation. That has to be given. And that is that I have exactly what I have said.
And as per this certificate, what is the date?
My lord, this certificate, date of birth is, my lord,
5/1/89.
5/1/1989.
5189.
Date of registration is, my lord, on 24th of May 2030. So birth is 19, my lord, 89. Registration is, my lord, 24th of May 2030.
So which should prevail according to you, that record in the service record or this birth
Record in the service records, my lord, that's the declaration by the father during the lifetime of the father. This kindly look, according to date of birth is 5th of January 1989. Recordal is, my lord, in 2013.
Yes, that we have seen much before the dispute arose.
Much before the dispute arose. That if this was
Nearly
the
a
case,
decade before the dispute.
yes, if this was the case, record should have been correct.
They could have.
But they have not done it, my lord. And my lord, my rules say, my lord, it will be by medical board in question. There is a further provision, my lord, that they have not availed. They have come to court. Court has sent it to Bardhaman Medical College, where is 36 plus minus 2. Whether it could have been done.
No, anybody has doubted the veracity of this registration certificate.
My lord, this, my lord, there is an order of rejection, my lord, given, my lord, by
No,
is
that
not-
rejection is not considering this certificate because it was not produced. That you have said.
Yes.
But it is
That is
without
part of the
considering.
writ petition, my lord. Of the writ petition, that is not given to the authorities in question. That is part of the writ petition.
So unless it is verified and found that it is not a genuine document, whether it should be considered or not, that is the only issue today.
That is, my lord, he has given after, my lord, much. This is supplied to me much after the death in question to the coal company. My lord, because records I show, my lord, much prior to this, my lord,
This was not produced in the writ proceeding.
This was produced. This is there. This is part of the writ.
Part of the record.
Part of the writ. He has filed a.
Why it was not relied upon? Why Bardhaman Medical College was asked to assess?
No, you have, my lord, in the writ application, it was annexed.
এটা রিটে ছিল তো।
Yes.
This is part of the writ application.
This
My lord,
writ
writ court,
application,
my lord, send it to Bardhaman Medical
my lord, resolve the dispute, my lord, for once for all, send before the medical.
The normal, subject to whatever any other law that you may produce, such document issued in routine course of business by a government authority under a process, under an act or statute, and arising much prior to the dispute, that is the best, most preferred document.
Let them verify, my
As far
lord.
as an age is concerned.
Let them verify.
I have not got a chance to verify it
So
at all.
therefore, we are saying, unless there is a dispute
Absolutely,
about
is absolutely correct.
about
My lord, I'll verify this, my lord. My lord, I did not get a chance because this was given in the writ court.
So you are you relying on this?
I am relying this certificate as well as medical board, my lord.
You cannot rely on both. You have to choose today whether you want to rely on this certificate or you want to rely on the board.
No, I am
Take a stand.
relying both. As to why, my lord, I am telling, my lord, they have not accepted the certificate. First thing. Second thing, my lord, they have accepted the order passed by the single bench, and they have not objected that order. When they found that the medical board is against them, now they are challenging both orders. How they can challenge both orders before your lordships? If your lordships, my lord, consider, my lord, 105 of the CPC, analogous to 97, section 97 of the CPC, they are barred to, my lord, challenge that question, that part. So they have accepted that order.
Section 95 of the CPC.
97.
90, well, 90, 105 of CPC says,
There are
my lord,
5 and as well as
my lord,
97.
save as otherwise expressly provided, no appeal shall lie from a following order of a court in exercise of his original or
And
appellate
this part,
jurisdiction,
my lord,
but a decree
directing-
appealed from or an error on defect
directing the
irregularity in
medical
any
board-
order affecting the decision of the
It's
case
appealable order.
set forth as a
Clause
ground of
15 of
objection.
the latest
How
patent
it
act.
is appellable, my lord? The High Court merely says you go to some other board to get a report. Is it appellable?
Mr. Ghosh,
Lordship,
just come to the preamble of the Memorandum of Appeal.
memorandum of appeal. কি হয়েছে? কি লিখেছিস? Yes, Lordship.
Page 4.
Yes, Lordship.
Being agreed by and discussing the judgment and order dated 10th December 2025.
Yes. Yes.
Where is the earlier order?
Earlier order. Earlier order, my lord.
It is what you are saying that
Yes.
comes with the Parliament order for 1022. Just
No,
saying
it
that
comes
also.
absolutely, absolutely. That earlier order is not a judgment, my lord. It barely says medical board will do it.
No, that is what what you are suggesting that 105, just consider 105.
Yes.
The interlocutory order. That is why we have the consider constructive res judicata in a single procedure.
Yes.
So therefore the order was there.
Yes.
You chooses not to challenge. Then you have a right to challenge if you challenge
In the final order.
final. Now you are challenging this final order.
Final order.
Final order, but you have to mention that this including this order.
Very well, my lord. That's the
So that
technique.
would not be
That's a technique. My lord, normally we don't do it, my lord. Normally, my lord, Lordship knows much more CPC than I do.
No, no,
In
no.
a decree, my lord, if
Decree
challenge from a
encompasses
decree, I do
everything.
not write that order.
When you are taking 8 of 105,
Yes.
then you have to specifically
My lord,
spell down
that I have
the
learned
memo.
today. That I have learned today, my lord.
No.
I never do not do that, my lord. That I have learned today, my lord.
Which I have learned,
Yes.
whether it is correct
That I have
or not,
learned today.
it is just very-
My learned friend, because that's my, because all orders need not be challenged. But
That
to
is-
mention it here, my lord, this is I have learned today, my lord, that you have to mention it here also.
Other sense. Then you are putting the other side
That is
into
that is
surprise
that's
that you are challenging that order also.
yes, yes, absolutely, absolutely, absolutely.
Then
We'll
that is why order 4222.
Yes.
That you did not to challenge the findings, but you have a right to challenge the findings. If you
To write
choose
it
not-
there, my lord, to be very honest, I will
not to challenge the finding,
No, that should be done. That's why.
I'll do that, my lord. That's why I'm doing it,
that
my
is
lord.
why you say
Yes,
that
my lord.
if you did not challenge the finding, you can defend or challenge.
Normally, my lord, without writing I did, but my lord has said so, my lord. Today I've
No,
learned
no,
something.
I, speaking for myself, we should not be proceeding as if we are proceeding in a case under CPC. We are in continuity of 226.
Yes, yes.
The procedure, principles applicable, yes.
Yes,
but
Rule 53. my lord.
they will not get in the way of
But
exercise.
that's the principle, because my medical,
My
because
lord, apart from this, my lord, if you also
Challenging.
consider their medical board. Medical board says 30 to 35 to 40 years.
You have annexed the certificate, sir.
Yes,
You have annexed the certificate.
yes.
Yes.
My lord, I'm still, my lord, I'm relying. Otherwise, I would not have, my lord, annexed the certificate. They have, my lord, the chance because 2 years back the writ application was filed. My lord, I am sure that they have verified. They are not disclosing.
well, how do I verify it? Is
Why they will not verify? I have, my lord, annexed in the, my lord.
Anyway, that is a presumptuous submission.
Let them verify. No objection, my lord. Let them verify.
very well, I'll do that, my lord.
What is
I
the difficulty?
need the chance. This was
What is the
part of
difficulty?
the application which I showed you.
What is the difficulty to verify, my lord?
That's why we asked you.
Yes, yes, let them verify, my
That's
lord.
why we asked you.
Let them
This is
verify.
the most preferred document
Yes.
as
Not only that, he has his Aadhaar and other documents given. That is also not produced.
that will not. That will not look like this. Surely not.
I will have to, my lord, this is not the basis whereby, my lord, it has been granted.
So you want to verify it, we should keep it pending or we should dispose it off that you verify it and you give him the employment.
Right. Yes. My lord, we'll verify and give him the appointment, my lord, subject to what, my lord, we find, my lord. If he is agreeable to that, it will, my lord. আরে ভেরিফাই যদি হয়ে যায় ওটা কারেক্ট থাকে ওর বেসিসে অ্যাপয়েন্টমেন্ট দেবে দেব সার্টিফিকেট পেন্ডিং রাখবে না চলে যাবে কি করবে পেন্ডিং রাখবে We'll verify, my lord, that's the instruction, my lord. This matters, my lord, I go by instruction because it's
No,
authorized.
tell us, therefore we asked you.
My lord, keeps it, my lord, we'll verify and come back, my lord. It can be
So who is
finished.
the authority who has issued it?
My lord, the authority who has issued, my lord, it's my lord,
Sub-register.
sub-register, to.
No, name of the
Gram Panchayat, my lord. Kendra Gram
Panchayat.
Kendra Gram
We are
Panchayat.
adjourning it 3 weeks. In the meantime, let them verify it.
We'll write to Kendra Gram Panchayat, my lord.
Matter number 4. Listen.
আমি আসি কোনটা তোমার তো আমি আপনি করবো কিনা স্ট্রাকচার দিতে হবে এই তো হয়ে গেছে এই সাইড পাল্টা আবার তো এখনই পরেরটা আছে টাইম নিয়ে নেবো বলবে এই সাইড পাল্টানো কিছু হবে না ওই মেমো কোনটা মেমোটা this matter needs some time because I am challenging entry order. The thing is, the application is also not under the hearing list. So I have challenged
What is the entry model under challenge?
refusal of entry order. I have already challenged this. So
may I acha bole now
time nahi na
no may I submit one thing?
Why should we keep it pending?
The problem is refusal and in
For what, sir?
well that will continue or not, that is to be my lord.
No, we have to see whether there is a case for it or an entry model. Why entry model should have been granted?
your losses. This was in regard to promotion. DPS stat or offer made, appointments made, but nothing remains in the appellate list.
Look, you will give me 1 week time. I will come to my instructions so that I will not pass any order, my lord.
Very well, not today. As prayed by learned advocate for the, he is also appearing, sir, as prayed by learned advocate.
For respondent number 2 to 6, Lordship. Need Millard for some times, Lordship, for Millard the on yes, Lordship. For Millard the fire incident, Millard it was apprised before your Lordship on the last occasion in Midjagalep Street fire incident. Millard in our office premises. Lordship. Same case, no, not the same case, Lordship, but the advocate on record, Lordship, same. On behalf of respondent number 2 to 6.
Yes, you are for the appellant.
Mr. I'm the petitioner, Your Lordship. Lordship, I'm led by Advocate Shubhoshi Chatterjee is currently engaged in code number 35. I'm paying for short passover, my lord.
May your Lordship be kindly be adjourned.
State. What is the issue? You tell us what is the issue.
Compassionate appointment, the government
2007. Yes.
Now, one of the conditions of compassionate appointment. Now, the order that has been passed in the institution has been passed against my learned friend. According to subject to inform my judge. That I will not be pleased to investigate the fiscal tactic. Order, I will be there.
Page 7. Yes.
But this matter I laid by Mr. Fokusai Chatterjee, my lord.
He will come.
Lord, kindly come to
He is
page.
already here. Catch your breath. So there is, well, first thing, is there or is there no scheme?
Yes, my lord, that was the view expressed by the learned single judge. But my submission is that this state observation was wrong. My lord, kindly come to page 31. This is the scheme under which the application for compassionate appointment could be made. My lord, this is a scheme of 2011, whereas in pursuance to the Labor Department's notification number,
Date of demise,
2007.
date please.
My lord, so for the 76, date of demise,
29/11/2007. 29/11/2007.
29/11/2007, 17. This is the death certificate. Well, you can see from the
So this scheme of 2011 has a retrospective effect.
But if you lordship kindly read this, whereas in pursuance to the Labor Department's notification number 142, MP dated 1/11/2007, the governor is pleased to formulate a policy for with the prayers of the appointment or financial assistance on compassionate ground received by the state transport undertakings from the dependents of the employees of STUs who die in harness or retire permanently incapacitated from service. These are as under. This CSTC is included, my lord. Thereafter in page
But in CST or tramways?
CSTC, my lord. My lord, this is SBSTC, my lord. Page number 19.
No, there's no dispute about that.
Yes, sir. So, my lord, if your lordship kindly turn to page number 34, clause 5, it is hereby clarified that the family of the deceased or prematurely retired employee shall be considered to be in immediate assistance if any of the two conditions mentioned below is satisfied. The monthly income.
No, we are asking you,
Yes, sir.
this notification of 13/1/11, does it contemplate a retrospective operation?
Yes, my lord.
In which provision?
My lord, you kindly take the first language only. The STU means employee is a person who is workers, regular and permanent employees. So the was term was there, my lord, in clause 2. So therefore, my lord, was who were the before 2011, they are also following under this. My lord, kindly come to clause 2. So this included employees means a person who is or was a regular and permanent employees of STU and all these things, my lord. So therefore, my lord, in my reading, my lord, it can be applied retrospectively, my lord. There may not be any hurdle. Now, my lord, kindly come to page 19.
Yes.
Well, if you kindly turn to page 19.
19.
19. Well, this is the family income certificate. Kindly, this was, I had to, this was submitted, and thereafter kindly come to the date. April 3, 2011. Joy Dash, with reference to her application for employment in CSTC
Is ground, he or she is requested to submit the family monthly income certificate from chairman, municipality, Gram Panchayat, Pradhan, Sabhapati, Panchayat Samiti, and any government gazetted officers to the concerned unit where deceased employees were attached for forwarding the undersigned immediately. Then these documents were asked from us. Thereafter, on the next page, they were considering it. January 2012. The employee following self-explanatory representation along with the disclosure acts directed to requested to take decisional actions in terms of the government rules. Then representation of my mother, who made the first application on behalf of me, and thereafter for such and such is given. Well, I'm skipping it. Then Lordship kindly come to page number 23. This is an appeal made in 2021. And why this appeal, Lordship? If your Lordship kindly come to paragraph number 3 of the appeal, page 23, Lordship will find that be it mentioned here that on 18 words, I made application before the authority concerned for my appointment on compassionate ground, and in response to my said application, the Deputy Managing Director of the corporation transmitted a letter, void number such and such, dated 1/8/2011, with direction to submit the family income certificate. I submitted that time. And your Lordship will find from that letter only that the date of my father's demise, my age was also recorded. So they were considering. But again, letters were made under this scheme itself, they were considering. Then Lordship kindly come to the order passed by the single bench. When I first came before this court, it was disposed of. So from 2007, your claim was pending. It was pending. But here, my lord, I will be.
Final order was passed.
No final order was passed. Kindly come to page 41.
When is the last action that was taken by them in this regard? What is the last action taken by them?
Prior to what has happened in 2021 only, they have taken me as a contractual staff. Well,
where is that order?
Well, there was no order. They asked, they allowed us to join.
In 21.
And I'm working there.
No, but you said that they asked you to give the details of your income and all these things.
Yes, all these things were.
This was last till which date?
2001 to page 19. And page 19 is the date.
19 and 23, 2 pages you referred.
And now that was passed after, when a honorable single bench of this court had directed them to consider in the light of a judgment passed by this court.
Page 19.
Page 19, my lord. That is the communication, my lord. Communication made to me by the Deputy Managing Director of the corporation.
So what is the date?
My lord, this was Lordship 15/2011.
It's not page 19. You're paging, every page has 3 page numbers. How do you file this? Every page has 3 page numbers. One is crossed, one is bold, one is light.
Well, they should have also. I take the responsibility. It is signed, my lordship can find it from the signature of the Deputy Managing Director. That is on 15/2/2011, my lord.
See, this is 20, this is 19. 15 to 11, yes.
Yes, ma'am. Now, Lordship, what has happened? If there was a first round of writ petition, my lord, the order can be annexed in seen from page number 40, my lord. This was disposed of by the Honorable Justice Ray. Lordship, here your Lordship will find page 40 and internal page 2 of this judgment in the page 41. I'm reading from the second paragraph, page 41, my lord.
It is of 17/12/25.
My lord, 22nd May 2025, my lord. Page 40.
Be kind to us, sir.
Well,
Be kind to us.
well, I,
How do we follow this? Nothing, no paging, nothing. We don't know what you're talking about. How do we consider what you're saying? See, this says page 37. Now the next page is supposed to be 38. Then appears an order of 17, 12, 25. This order you are not referring. Which order you are referring to?
my lord, I'm referring to my lord, 17/12/2025 order is the order impugned, my lord.
Yes.
Prior to this order, my lord, passed, there was another round of
40 be before 37. That's what we are wondering. Your last page is 37. And you are saying page 40.
It is in my copy, it is 40, my lord, I'm not sure it is. My lord, I stand corrected, my lord. There is an order, lordship was. My lord, may
22nd May 25.
Yes, my lord. Your lordship was found, my lord.
Yes, we have found it.
I'm very sorry, my lord. I should have, my lord, looked into this. My
Please have a look at the brief before you argue. Yes.
lord. Kindly come to page.
This is a writ filed by the same petitioner earlier.
The first round of writ petition, my lord.
In 23.
23. My lord, kindly come to internal page 2.
Yes.
Second paragraph onwards.
Yes.
Relying on an order passed by a coordinate bench dated 27/2022 in WPO 1240 of 2021 in the matter of Upendra Kumar versus State of West Bengal and others, such and such appearing for the petitioner submits that under the similar fact situation, the coordinate bench directed the respondent number 2 to consider the case of the applicant seeking compassionate appointment along with other consequential directions as would be evident from the order. Now, there was the direction to dispose of my application also in view of the Upendra Kumar Supra, Lordship, that can be also found from disposal of petition same right in the matter of Upendra Kumar Supra, and there was the judgment which was pronounced. Kindly come to paragraph number, last paragraph, which should be featured from internal page 3. It is needless to mention that while deciding the issue, the respondent number 4 shall also consider the order of the coordinate bench in the matter of Upendra Kumar Supra and their subsequent decisions, which are made part of the writ petition. In the document in page 29 of the writ petition, it appears the respondent number 2 has already acted upon the said decision of the coordinate bench passed in an application made by another candidate similarly placed with me. Well, thereafter, my lord, I would like to refer this Upendra Kumar Supra, my lord, before your lordship. Here's this judgment, Upendra Kumar Supra. Judgment of Upendra Kumar. My lord, and this made the foundation of my argument in the second round of writ petition. Well, I'm reading the facts because it would be essential. The petitioner's father was a tram driver in Calcutta Tramways Company, 1978 Limited, in short CTC, now known as West Bengal Transport Corporation. The petitioner's father died in harness on 29th October 2010, leaving behind the petitioner and his mother as members of his family. The petitioner's mother made an application on 27 January 2011 requesting the employer to grant appointment on compassionate ground to the petitioner. After passage of 10 years, the petitioner was informed by WBTC that the employer has taken a decision to appoint the petitioner on compassionate ground in the post of conductor on contractual basis.
The decision so taken has been sent to the Transport Department, Government of West Bengal for approval, but no approval till 21st August 2021 was received by West Bengal Tramways Company. It is now been settled that compassionate appointment, I am from is a source to the body for saving of the sudden financial crisis arising out of the loss of soul brain earner. Dealing granting such and such appointment frustrates the whole object of the scheme. Right? Is exception of the problem. In instant case, it is not clear on the basis of which scheme the petitioner's application was considered and a decision was arrived at to give the petitioners an appointment of compassionate ground in the post of a conductor on contractual basis. As communicated by the memo dated 24th August 2021.
So he got the appointment.
He got the appointment as contractual basis. As I will
know that petitioner, in compliance of this single judge order, he got the
appointment.
Permanent appointment.
Well, this was one of the foundation of my arguments before the. Now let kindly come to the decision which was passed subsequently after passing of this order, and where they have not considered the thing. My lord, kindly come to the next page. That is the reason order, which is annexed page 44 onwards. But I'm not sure. Before I refer this, my lord, I should be sure about the pagination, my lord.
We will find it somehow.
In my copy, my lord, it is.
What is the date?
Well, the date is 19/2025. This is the date of communication to me.
Yeah, got it.
And the order was passed on 4/8/2025. The reason. Well, the entire reason order, if I read it, my lord, from the second paragraph, it appears that there was a compassionate appointment made in CTC at the instance of a court order dated 27/4/2022 passed in WPO such and such, and 2 was under the direction of the Government of West Bengal in Transport Department. In the writ petition, he stated and contended that the respondent number 2 is a government company registered under Section 617 of the Companies Act 1956. That is out and out a misleading statement. He further tried to mix the West Bengal Transport Corporation Limited with the Calcutta State Transport Corporation, which are two separate legal entities. The Calcutta State Transport Corporation has never been transformed to West Bengal Transport Corporation Limited. However, it transpires from the records that at least till 9th April 2003, there was no scheme for compassionate appointment whatsoever in corporation. It is pertinent to state that any such scheme should be framed and or floated and or approved by the Transport Department, Government of West Bengal. It reveals from the record that the Government of West Bengal Transport Department vide its memo dated 9/4/2003 as one-time measure conveyed its approval for employment on compassionate ground against the die-in harness category only for certain specific number of enlisted candidates seeking appointment on compassionate ground under die-in harness category. With the passage of time, after absorption and the offering those candidates appointment on compassionate ground in the corporation, the said one-time approval and or the said one-time scheme for compassionate appointment does not exist. Be that as it may, except such a one-time approval of for appointment of corporation against a specific number of candidates in die-in harness category, neither at the relevant time nor at the present moment there is any scheme for appointment on compassionate ground either on die-in harness category or in the other category in the corporation. My lord, I join the issue here, my lord. In my view, my lord, this is contradictory with the scheme which, as I have referred, which was formulated in 2011. Further, undoubtedly, the object of granting compassionate appointment is to financially assist a bereaved family and provide immediate succor by averting a financial crisis that the dependents of a deceased employee may face due to sudden death of the breadwinner of the family, provided there is a scheme for such employment on compassionate ground. In fact, the Labour Department, Government of West Bengal, notification such and such dated 3rd September 2013 withdrew and superseded its all previous orders and notifications regulating the appointment on compassionate ground and thereby restricted the scope of such scheme for compassionate appointment. Again, another observations in my humble reading, my lord, this is not correct. In 2013, by issuing the notification number 251, it has been specifically mentioned that the scheme for compassionate employment is only for the employees of the state government department, and all the earlier notifications issued for the compassionate employment have been superseded by the notification number such and such. In fact, there is no scheme after 2013. Here also, my lord, in my humble reading of this, my lord, learned single judge has heard in law. In the manner whatsoever in CSTC or any other STUs, State Transport Corporation, as such, in absence of this scheme, the prayer for compassionate employment cannot be exceeded to. But it is pertinent to mention here that while dealing with the matter, a recent reportable judgment was cited by the office. The Honorable Apex Court, in its judgment dated such and such, in the civil appeal number, in absence of any policy, compassionate appointment cannot be granted. Secondly, assuming that there was a policy, it would be no redeeming purpose of the direct, the application for the appointment on compassionate ground be considered and decided several times. Yes. Well, thereafter, my lord, I will directly coming to the impugned order. While passing the impugned order, my lord, the learned single judge, apart from all this, my lord, he had also taken another ground, my lord, that is in regard to the application, and he was pleased to refer one of the judgments, cite one of the judgment passed by the this court, my lord. Kindly come to the paragraph number 7 of the impugned order, my lord. Moreover, what is striking was indisputably minor on the date of death on 29th November 2007. It appears from the affidavit in connection with the present writ petition that the present age of the petitioner is 32 years. Admitted position, my lord. Therefore, on the date of the death of the employee on 29th November 2007, he was minor.
He was?
He was minor.
Yes.
In the case relating to the appointment on the compassionate ground, unless scheme provides a minor at the time of the death of the employee has no right to be considered for the appointment on compassionate ground. In the ratio of Upendra Kumar Supra will not apply. In present case, since it was not a case of appointment of a candidate who was minor at the time of death of employee, in this regard, reliance is placed on a judgment, that is Arindam Chaudhary versus State of West Bengal and others, and Anirban Jana versus State of West Bengal and others. In the said judgment, the Honorable Division Bench succinctly decided the right of a minor candidate cannot be preserved till he becomes major for obtaining appointment on compassionate ground if the scheme is silent on the issue. My lord, here, my lord, in the view of the decision, so my lord, the last point raised by the learned, taken by the learned single judge, my lord, I have taken the judgment of Arindam and Anirban. My lord, may I hand over a copy of the judgment? And in my reading also, this judgment is also not correctly applied, my lord. It may subject to correction, my lord. May I? My lord, this is a judgment written by the Honorable Justice Dotto and Justice Vivek Chaudhary. Their lordships, they were. My lord, kindly come to paragraph number 5. However, before looking into the individual cases of Arindam and Anirban, we may summarize below certain well-settled principles. Public employment in offices and posts under the state or its instrumentalities or any other authority covered by Article 12 of the Constitution must be in accordance with Article 14 and 16 of the Constitution, meaning thereby the appointment must be preceded by an invitation to the public for offering one's candidature for consideration, providing equal opportunities to each of the applicants to participate in the process. Appointment based on solely dissent of the inimical to the constitutional scheme, appointment compassionate ground, lordship then directly come to after this. Now would be appropriate paragraph number 7. Now it would be appropriate to examine the claims of Anirban and Anirban in the light of the aforesaid principles. Now jotted down all the principles A to U, then kindly come to these facts. Now it would be appropriate. Falguni, mother of the Arindam, while working as a staff nurse in the district hospital Midnapur, passed away on December 4, 2006, leaving behind her as her surviving heirs her son Arindam and husband Bidhan. Bidhan had applied for compassionate appointment. There he left the husband. Husband made the application for compassionate appointment for self on February 15, 2008. He was 48 years old then. An inquiry committee constituted to consider the application made by the recommendation dated 7th March 2009 for immediate financial assistance to the family was dependent on the applicant. During the pendency of such application, Arindam attained majority on April 1, 2013. This is a case, my lord, it was never been considered at all. There, during the consideration, it was already inquiry committee was formulated. Since despite such recommendation, there was no positive result, another application followed on May 2, 2013 at the instance of Bidhan seeking Arindam's appointment on compassionate ground. The first application Bidhan was rejected on April 22, 2015 on the twin grounds Bidhan was overaged and that the family members of Falguni were not in financial distress. There were two grounds. Immediately thereafter, Arindam sent the reminder. Now, my lord, kindly come to paragraph number 11. In exercise of the power conferred by the section 3C of the West Bengal Regulation of Recruitment of the State Government Establishment and Establishments of the Public Undertaking Statutory Bodies, Government Companies and Local Authorities Act 1999, were issued while the former notification identified who would comprise the exempted category candidates and the latter provided for the procedure to be followed in the matter of the compassionate appointment for such exempted category. So entire issue was based on that. Entire issue was Built upon this, my lord, exempted category candidates in terms of the forward notification under the general procedure to be followed in respect of the different exempted categories engrafted in the later notification. One of the conditions is this: if the administrative department decides that a particular case is fit where employment on compassionate ground could be given, a suitable vacancy has to be identified under the appointing authority concerned by providing employment subject to conditions of the candidate satisfies the qualification and other requirement prescribed for the recruitment of the post. In the middle of 2005, the government introduced principle and procedures to be followed in dealing with the issue of appointment on compassionate ground to the dependents of the employee who die in harness or who retire prematurely on being declared permanently incapacitated by notification number 97 EMP dated 6 June 2005. Paragraph 9 of the notification stipulated that unless there are exceptional reasons, the department to which the name of the person is forwarded by the Labor Department in terms of paragraph 8 thereof will issue a letter of appointment. But my case is that they have not only considered, they have also recruited me as one of the employee, as however it is contractual employment. They've taken me in that candidate forwarded appointment by the Labor Department pursuant to nodal committee satisfies qualifications, entry such and such. Now, may I kindly come to the paragraph 18. Although the relevant clauses of the applicable notifications have not been referred to above, the procedure appears to be clear on a conspectus thereof. A dependent of an employee dying in harness, retiring owing to physical incapacitation, who is in need of immediate assistance, has to pass through a multi-tier check process. The first is relatable to the ascertainment of the need of assistance, which is of the paramount importance. Unless there is a crisis in the family arising out of the death or incapacitation, there can be no valid claim requiring examination. Secondly, the committee which examines the claim at first instance, apart from ascertaining whether the family of the deceased retired employee is in dire need of assistance, ought to also be idly examine whether the dependent who has applied is otherwise qualified to hold the post under the government. If, however, the committee fails to examine this aspect, it is always open to the government in the relevant administrative department to verify whether the dependent who has been recommended is otherwise qualified. In case the applying dependent falls short of these qualifications, any of the qualifications, it is also open to the government to ascertain whether any other dependent member of the family is so qualified and interested to obtain employment to further the object of compassionate appointment. If so, he could be considered. Once a dependent member is found to be eligible for the basic qualifications, he is required to be sent to the medical examination and his antecedents verified prior to the finally accepting the recommendation. Only upon clearance from the quarters being received would the offer of the appointment flow. While considering the claims of the petitioner, we need to keep the aforesaid summary of the procedure in the mind apart from the judicial pronouncement. Falguni was 46 years of age when she died. She had put the little less than 20 years in service. Therefore, the application for compassionate appointment by her heirs would not be barred by the reason for paragraph 2(1) of the notification. The application for the compassionate appointment of Bidhan was disposed of on 22nd April 2015 by the respondents. Several modification clarifications were issued. Meanwhile, the respect of the guidelines of the compassionate appointment. In none of this was any provision made for the entry of an individual into government service above 40 years and below 18 years of age. Since Bidhan did not belong to any of the backward classes, relaxation of the upper class was not given. But what I wanted to mean, kindly come to then, Lordship will find from paragraph 31, there was a distinction made by the Honorable Division Bench basis of the Rafiq Masi, the paragraph number 12, and then their Lordships has ultimately in paragraph 37 our attention has not been drawn to the provision of the notification which preserve the rights of the minor. Applicant to obtain the appointment on compassionate ground till he attains majority from the principles summarized in paragraph 5 supra, that A to U principles. It is clear that an applicant for the compassionate appointment does not acquire a right of appointment only upon proving the distressed condition of the family members of the employee who has died in harness. An aspirant for the post must have other necessary qualifications, which inter alia would include being the required age of the entry in service, possessing the minimum educational qualifications, and bearing good moral character as well as health. Financial crisis would not automatically guarantee the appointment. If there is any deficiency, such deficiency can be relaxed by the government, but not by any direction of the court. Needless to observe, a court by issuing mandamus cannot direct the government to act contrary to law. In my humble submission, the entire argument has been summarized in this paragraph, and here categorical these criteria have been settled by the division bench in my reading, my lord. An aspirant for the post must have the other necessary qualifications, which inter alia would include being the required age of entry in service, possessing the minimum educational qualifications, and others. Bearing good moral character, as good health. Financial crisis would not automatically guarantee an appointment. If there is deficiency, such deficiency can be relaxed by the government, but not by the court. Now, on the basis of that, this judgment was pronounced. In my humble submission, my lord, this application of this judgment in this particular, while deciding this case, is in my reading, my lord, is incorrect, my lord. Now, my lord, I'm not referring, because this was a reason provided by the court, and I say that, my lord, this application of this judgment is, my lord, in my reading is incorrect, my lord, here. So, my lord, on the basis of that, this judgment, my lord, this petitioner's case should have been considered. The question was, my lord, whether under this scheme, whether he can be appointed under as a contractual employee. Once he is appointed as a contractual employee, my lord, then whether the provision allowed them to appoint anybody under this dying harness category as a contractual employee. Thereafter, same supra, my lord, I have applied the principle I have referred, my lord. Upendra Kumar clearly says, my lord, that this has to be that was considered in case of a contractual employee whose service was given, the permanent service has been given. So at this stage, my lord, I beseech your lordship to consider this case in the light of that Upendra Kumar supra, my lord. That is my submission, my lord. And if your lordship wants, my lord, another scheme, another, I can message.
Heard the learned advocate for the appellant. Stop. The sum and substance of the present dispute is a claim for compassionate appointment of the writ petitioner, whose father died in harness while working under the West Bengal Transport Corporation. Full stop. On 29/11/2007. Full stop. As on the date of demise of the petitioner's father, the petitioner was aged 7 years old. Full stop. The writ petition was filed for the first time, asserting a claim for compassionate appointment in the year 2025. The same was rejected. The same was disposed of, directing a consideration of the petitioner's claim. To stop, the petitioner's claim thereafter was considered and rejected by the authorities, namely the managing director of the Calcutta State Transport Corporation, by an order communicated by a covering letter dated 19/9/2025. So the same was put to challenge in the second writ petition filed by the petitioner which has been dismissed by the learned single judge, giving rise to the present intra-court appeal. Stop. The learned single judge, after considering the petitioner's claim, did not find the claim to be admissible. Full stop. We have considered the rival submissions and the record. Full stop. It appears that the petitioner's father died while in harness, serving in the West Bengal Transport Corporation Limited as a fitter. Full stop. The petitioner has enclosed copy of communications dated
Item number 6.
Affidavit of service to
Affidavit of HON'BLE. Item number 6, Mr. Pradeep Kumar Datta appearing. Who? Mr. Pradeep Kumar Datta, Senior Counsel, appearing on behalf of the appellant, Millard, by consent of the parties that are paying not to be asked.
He told me that he is having the matter in another court. It may simple make it not today, my lord.
Then when will it come? That's the point. We are not having this bench every day.
Okay.
Madam, Mr. Datta is coming.
তুমি শুরু করো, অর্ডারটা পড়ো।
তোমার
অর্ডারটা পড়ো তখন।
Location.
Very well. Not today. Call the next time. Keep it on the next day. Call the next.
Item number 7. Eight.
Item number 7 and 8, Your Lordship. My senior, Miss Amrita Pandey, is leading me. Lordship, due to her fracture on her foot, Your Lordship, she couldn't come to court. So, Lordship, I'm praying for 14 days accommodation.
We are informed by MS so-and-so
Item number 9.
9, my lord. I am for the appellant, my lord. Here is, my lord, it's regarding the MMCC, but the point is, issue is different. We are not saying that the period of MMCC or whatever it is, my lord. Here, my lord, only the point is that whether an appointment being offered and accepted and thereafter not joined.
Compassionate appointment.
Yes. Person died, employment claimed by one of the dependents. Date of death, my lord, coming, my lord. Date of death 22nd May 1998.
98.
98.
And when you offered the appointment?
My lord, appointment was made, my lord, on 2001, 7/11/2001, which is annexed at page 49. Letter of appointment was issued.
Page 49.
Page 49, your lordship will see that is not disputed, my lord. This is the letter of appointment. It was given to Sriram Maji, the son of the workman concerned.
What is PR?
As PR, underground loader.
What is PR?
Well, PR I cannot say right now, but it's a Ignition underground loader.
He didn't join.
But he accepted this, but he didn't join. 10 years thereafter, my lord, an application was made by his sister, and that was processed by ECL. It was not that, my lord, it was not processed, it was processed by ECL.
What is the date of her application?
My lord, my lord, date is not discerned, my lord, but it's in 2010. But Sriram Maji, my lord, this person, my lord, who was given the appointment, my lord, as the son, he endorsed a no objection, which is at page 51 on 29th of October 2010. Page 51. The legible typed copy is at page 51A.
(29/9/2010). My God.
Page 51A.
What happened? It was
Now, thereafter, my lord, it was processed. It was processed. Though it should not have been, my lord.
The application of 29/10/2010 was processed.
Processed.
What it resulted
Now,
in what?
what happened thereafter, my lord? The screening was done and the initial medical examination of this Sukurmani Mejan, the writ petitioner, was also done, my lord. My lord, if your lordship comes to page 52, the better copy is at page 50.
So the younger daughter is before us.
Yes, my lord.
The younger daughter was before the writ court.
Yes, my lord. The daughter was before the writ court, my lord.
Then what happened?
My lord, it was processed thereafter, my lord. Process screening was done, my lord, and thereafter ECL issued a letter, my lord, on 11th of January 2016 at page 76 to cure shortcomings, my lord. Page 76.
Very well. Then what happened?
It went on, my lord. On the issued about 4 years, writ petition issued a letter on.
And all this time the brother was not working.
Not brother, didn't work.
Yes.
He was appointed, but he didn't work.
No MMCC, no payment of salary.
No payment of salary, no MMCC, my lord, because salary was to be paid only when he worked.
Yes, yes, obviously. Therefore, no.
Because we said, my lord, so my lord, ultimately this was processed to some extent, but ultimately it was not finalized. So writ petition was filed, my lord, and in the writ petition, my lord, that this order which has been assailed, my lord, it was passed. The order, my lord, is before your lordship today, is at page 120, my lord. It starts at page 120. This is the order, my lord. I think your lordship has gone through the order. Now, I have here, my lord, the points which I urge before your lordship today. That undoubtedly, my lord, the NCW is binding upon both the employees and the employers, as the lordship knows. Now, my lord, what does the NCW provides? That one employment against one death, and MMCC is in lieu of employment. I'm not onto those points which your lordship I heard, my lord, in the earlier matters.
Ultimately, it is a claim for MMCC.
My lord, if there it is seen in this way, my lord, then in that event, my lord, then this NCW's other provisions are not required. Then only this, that a person dies, anytime you come, you have to pay this.
Now in the writ petition, this is the only thing.
It is said, but my lord, kindly see clause 9.31, what does it say? First, clause 9.31, may I hand up, my lord, this?
For what? For what? MMCC, there is no other claim. Then why
MMCC
9.3?
comes, my lord, only in lieu of employment. Only in lieu of employment. Once, and employment is against one death. One employment.
So issuance of the appointment letter obliterates her claim for
Yes,
MMCC.
according to me, my lord, subject to correction, my lord, the moment I issue the appointment letter, my obligation comes to an end. Well, kindly think about this situation, my lord. A person, my lord, is provided with MMCC, is provided with employment. The basic view is the same, to bail out the family of the bereaved, of the worker who has died, my lord, from the difficulties or the financial difficulties which the family is facing due to the sole breadwinner. The basic tenets always apply, my lord, and that's why MMCC is in lieu of that. Now, once I proceed with the employment, my lord, my obligation comes to an end. So the chapter, immediately the doors close. The doors get closed immediately. Now, if whether he joined, I would have understood if it had been a case that he died prior to joining. He did not get the opportunity, he did not get the scope to join. Now, my lord, once I offered the employment and issued this appointment letter, the chapter comes to an end. Thereafter, the question of relinquishment of rights, if any, would have arisen only in respect of the employment of the son who has already been appointed. Because he cannot say that I relinquish my right. What right he is relinquishing? Because he has already exercised that right, and we have already taken up that, and we have already issued the letter of appointment. Once we issue the letter of appointment, so no further right exists. Today, my lord, no further right exists, because NCWA says, my lord, why I am repeating, and at the cost of repetition, I am saying, my lord, that it's clear under 9.3.1 that one appointment against one death, one employment against one death. There cannot be multiple appointments. There may be 5 dependents, 4 dependents. Each cannot claim. Each may have a right.
Each is not claiming, only one is claiming.
One claimed, we have made it. The moment we have made it, we have given the appointment.
We have taken action against those persons who were asking for all these documents. We have proceeded against those officers who were asking for these documents and making her run from pillar to post. What do you have done against them?
My lord, we have done, so far records are concerned presently, my lord, I can say from the records there is nothing.
Why you have not proceeded against
them? Proceed, man.
Yes, you should proceed.
I will proceed. Why they have
proceeded?
Why they have done so?
All the officers.
Why they have done so?
It has traveled to whichever level, highest level.
Why they have done so?
See the communication from which.
Yes, I have seen, my lord, and that's a wrong on their part. I am saying, my lord, that's a wrong on their part,
and for that wrong she should suffer.
No, my lord, it's not the question of only she is suffering. It's the question whether the NCWA permits or not.
Yes, that we have understood.
Whether the NCWA permits or not. My lord, here this is the only question. I, my lord, on the earlier occasion also said that's a very short point. That one.
Which provision you are relying upon?
Yes. First, my lord, kindly see 9.3.1. It had to be. My lord. Nine point 3.1. My lord has got it. May I? Employment would be provided to one dependent of workers who are disabled permanently and also those who die while in service. This provision will be implemented as follows. Then 9.3.2, my lord, insofar as female dependents are concerned, their employment payment of money will be governed by para 9.5.0. So it flows from 9.3.0, provision of employment to dependents. 9.3.1 says clearly that employment will to one dependent of workers. So one employment against one death. We provided that because I have already shown this appointment letter, my lord. They did nothing. My lord, he didn't join. He kept mum for 10 years. After 10 years, this letter was issued. And ECL, my lord, officers, they proceeded. I say, my lord, they proceeded wrongly. They proceeded wrongly. But that wrong should not be continued. And, my lord, that cannot be a basis for providing the employment or MMCC. Because why I was saying.
Who has said to provide employment?
Because MMCC is in lieu of employment. If the door is closed, my lord, for employment, the door is also closed for MMCC unless and until there is an age bar. Only in cases of age bar, that 45 years, in case of female, my lord, if she is above 45 years, then she is not entitled to get the employment, only MMCC remains. Then there she does not have any option. The only thing remains only to get the MMCC. But where from it flows? It flows from 9.3.0. Unless the right exists, my lord. I say today the right does not exist. I say today the right does not exist, my lord. I have a judgment. Order. I'm sorry, my lord. I tried my level best to get from other sites also, but only on this side it's available. This may I hand up? It's
of this court.
My lord, Jharkhand, Ranchi High Court.
Division bench.
Yes, division bench, my lord. দিচ্ছি তোমাকে কপি দিচ্ছি Here, my lord, the son was offered with the employment, but could not join because of his medical unfitness. Here, there is no such reason also.
Yes.
So, my lord, in short, my lord, my case is this. I will not take much of your lordship's time, my lord, repeating my pleadings, my lord. This is my case, my lord. So I say if I have done a wrong, but the wrong cannot be a basis to provide a relief. This is my case, my lord, in short.
Yes, take down. Heard the learned advocate for the appellant.